Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Good morning, everyone. Another day in the Karen Reed trial. I'm Linda Kenny Bodden, Justice Serve TV. Good morning. Let me see. I don't have my long range glasses on. I probably should put them on if I'm going to be talking with you and saying hello to everybody. The reason why we're watching for the stream in Canton right now, in Dedham, I should say, is that Karen Reed usually enters right now. And as soon as she does, Missy's going to put that up on the screen now. I can see a little bit better. Good morning, Louise P. Good morning, Curious Law Tuber. Ray of Light, you're up there. Hippiesta, Kimberly, to making a count. Hello to making a count. Louise P. Rhonda Hall, Kathy Bennett, Jojo Kitty, and of course our own Oasis Cat, who makes all these great breakouts for us. Sometimes we don't get to see them because I can't get to them quick enough, but they're there and they'll eventually go on the air. So we're watching right now, and I think this is, let me expand my screen here. Is that Alessi? Yes, that looks like Robert Alessi. Okay, and we heard him yesterday. He looks like he's a little camera shy this morning. He's certainly carrying. No wonder he has a good eating habits and carrying all that suitcase up those steps. And here we go. Thank you, Missy, for being so adept, making sure the cab, we were getting the feed of her walking into the courthouse. Alan Jackson. It's been a little red lately. I don't know if it's a sunburn or something or whatever, but I don't know if the cameras are looking a little red. Perfect posture. He reminds me of Tubi in this that perfect posture that he has. And there we go. There's Karen Reed. She's very involved with her defense, as you can see. Helping. There we go. I'm gonna let see if you can hear anything. If you can hear anything. No statement. No statement from her. Just looking, actually very involved in the defense again, carrying bags, pulling things up. In the old courthouses, let me tell you, when you have the trial bag and all your stuff in it, it's darn heavy. I mean, that's we're looking at it. And look at the fan is there. Now, what I'd like to do here is I want to talk about something we did on talked about the show last night. Late last night, after Guarino, or it wasn't late last night, yesterday afternoon, the Commonwealth filed a motion to prohibit public disclosure or reference to any investigation conducted by the Canton Police Department, the Fire Department, the State Police Department, blah, 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 into the death of Sandra Birchmore. Now, we've talked a lot on that show. One of the reasons we've talked about it is, as you all know, my husband, Dr. Michael Bodden, works for the civil attorneys, and he's the one who called it a homicide for them. He didn't say who does it. He just calls it a homicide, that it wasn't a suicide. As a result of all of that breaking it wide open, the feds opened an investigation. They hired their own forensic pathologist to confirm what my own husband, Michael, had said. And it turns out that there's a lot of interplay between the two. Guarino, who's testified of all the text messages and the extraction, he actually missed apparently 32,000 contacts between Farwell and the like in the Staunton Police Department with Sandra Birchmore. All right, who was being groomed since she was one of these like police things for young kids. I forget what they called it there. And then he started having sex with her when she was of the age, but clearly she'd been groomed for years and all. And a terrible, terrible situation. She was pregnant with his child when he's being charged with her death by the federal government. He's being charged with the murder of a witness, actually, by the federal government under their statutes. And his next hearing has been put off to July. Now, it's been put off for several reasons. I have my feeling about why it maybe have been put off. Perhaps there's a deal being struck with him investigating. We don't know. But anyhow, they wanted to question Guarino on the fact that he missed all those texts. That goes to his competency. He also missed the text that was deleted at 2:27, not text, Google search, that was deleted in Jen McCabe's phone. So, and as of yesterday, it was only the motion was allowed. I mean that the Commonwealth prohibited that the Commonwealth motions prohibit to reference the unrelated death of investigation was allowed, which means the motion was granted unless the Commonwealth opens the door. Okay, Judge Canoni, and so uh, I think it's ridiculous. I mean, I think that it goes to his competency. I think it goes to relevancy of how he's pulling the text on the phones, whether he's extracting properly. If he can't extract phones properly on another case, what makes us say that the phones that he's given us have extracted on this case? And also, you notice that when we heard about all the calls that Karen Reed was making, where she thought she was obviously being ghosted by John O'Keefe, the prosecution is going to argue that he was dead at that time. That what other calls did she talk about? Did we hear any calls from Jen McCabe to him that were left? What other calls? We didn't hear any of that because he didn't find it maybe on the phone. And so if he doesn't find something, it means it doesn't exist. But it may exist because we know that he, for lack of a better word, screwed up the Sandra Birchmore case. And you got to wonder about everything else. So I was pretty hot under the collar about that last night. I think it's another wrong ruling. And somebody had even texted me, by the way, as we wait for this to start, that they thought that the word is that the jury is liking Hank Brennan and liking the witnesses now. And I said and I've always told you that it is a danger to underestimate Hank Brennan. Why? He's a very good trial attorney. You may not like him. He's done I think, some sneaky, sleazy things in this case to get in Beverly Canoni after the defense team improperly, and in front of the cameras improperly. But he's clearly coached, and his witnesses have been told not to argue with any cross-examined, not to argue with Alan Jackson, just not to argue with Inetti, and they stay calm, right? They stay calm, and we have the benefit of the first trial, and we know a lot of the testimony is different and how they acted, but the jury is only seeing this testimony. So while I don't think this case at any level rises to a murder, I think the Commonwealth is kind of like really going after that second count. Well, maybe this will be so confusing to the jury. They'll just say pieces of taillight were found. It's around where she left him. She was drunk, and therefore that's it. You know, that you have somebody on the jury that does that. I don't see it. I don't see how you can get a conviction unless you can prove a collision, and that right now the Commonwealth can't prove a collision of any sort. The pieces that were found yesterday, come on. I mean, there's like a little teeny, what is it, 6 or 7 little teeny pieces. Don't know how they got there. Don't know when they got there. All right. Remember, they were looking, the CERT team came in. And by the way, I thought O'Hara was one of the second witness that I've seen that was pretty honest. That was, didn't try to shade testimony in any way. That, of course, the first witness was John O'Keefe's best friend, who really, talked about the relationship with he and Karen very nicely that John O'Keefe had with Karen Reed and all. I thought that was a wonderful witness, and I thought O'Hara yesterday, he looked like he had been duped at the very end, and I think he felt it because he wanted to see the SUV so he could know what he was looking for. And they told him about 5:30 in the afternoon that the SUV was on its way to being towed to the Sally port, and in fact, it had already been there. So they could have gone a mile away of seeing what he was actually looking for. And they didn't search the grass. Remember, they searched the street berm. So there's something iffy about those pieces. And even if there was a few pieces, remember she cracked the her taillight. She did hit another car on that taillight. But unless you can prove a collision, I don't see how in any stretch of the imagination the Commonwealth gets a conviction. Certainly, they'll get a conviction on murder, and the only way they're going to get a conviction on the second count is if the jury ignores all the rest and doesn't understand the concept of proof beyond a reasonable doubt, which is why I was critical of the first trial, that the defense didn't go there all the time. And I think that's where they constantly have to go now. They have to like put these things together. And Alan Jackson did open with it this time. He did open with proof beyond a reasonable doubt. And I thought that's the one mistake the defense had did in the first trial, because once you put on a defense of like this was all made up, that he was attacked in the house. John O'Keefe was attacked in the house by Chloe, and he was put out about 5 o'clock. Given the temperatures we heard, I mean, even the temperature guy with the cross examination, in my opinion, helping the defense. Right, Mr. Was it Gilmore or Gilman, who was on the witness stand yesterday? I thought he ended up kind of like helping the defense. That was my view of it, because of the coldness and all, and John's cell phone, and John's his cell phone only going down 7 degrees in a period of time that the temperature was going down. It sounded to me like that the body, if it would he were attacked inside by Chloe, had to be put outside somewhere later than, closer to more like 5 o'clock ish and all. And remember, then the snow starts coming down. I think it was who was it? O'Hara said, well, he didn't, or somebody said he didn't see any tracks from the house back to where he was getting the glass. But remember, the snow had really come down. Most of the snow came down after John O'Keefe's body was taken away. Most of that snow, of that 23.5 inches, came down after. And it turns out that at the critical time between 12 and 1, there was only about a half inch of snow on the ground, maybe an eighth of an inch of snow on the ground. It was kind of like a dusting. I think you could see cat's paws, but that's it. So light. So all these people coming in and out of the house had been there, a body just sprawled out there. And we know this lawn is much smaller than you all see. The prosecution loves to show these wide shots. Oh, let me look at the house from this angle up there. Well, then it looks like a football field, and it's not. Now, I am going to tell you, Michel Bryant is on his way to Canton Dedham. He should be there any moment. He certainly is going to be there for our lunch hour, but he's going to be doing some field work before he gets on the air with us. He's going to be getting possibly the plot plan. He wants to go back back at the 54 Fairview. He wants to look at that camera from the deputy chief's house, the Arlo camera, which apparently knows nothing, like everybody else in this case. I know nothing. I see nothing. I hear nothing. I only know that Karen Reed allegedly said, "I did it. I did it. I did it." Who the heck says that? It's I hit him. I hit him. I hit him. Whatever iteration of the alleged admission you want to say. And the Commonwealth has not put on any of the police officers that didn't hear that. They've not put on, the police officers that give them problems. They haven't put on the law enforcement proctor. We haven't heard Higgins. We haven't heard McCabe. We haven't heard, obviously, them putting on Brian Albert. Well, I don't know if he would hurt them. He'd be telling this story. But I think Hank Brennan's going to stay away from them all. I think he's not going to put them on. I don't think he's going to put Higgins on, because Higgins is the one who puts John in the house by saying there was a 6'2" man with dark hair who entered the house, and it could only be John O'Keefe. That's the issue of this case. There's so much on this case, right? There's so much on this case that gives rise to, what the heck happened? How did it happen? But in any event, the Commonwealth is shading everything. And this is why we tell people never talk to the police, because if they decide they want to go after you, they're going to shade everything. Now, I had a different take on all those calls that Karen Reed made all night for him. She said he could not come home. All right. Remember, he wanted her to come over. She's in Braintree, to take him to the bar so he could have a ride. They could do a lot of drinking, blah, 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 but she'd be the designated driver. Because apparently everybody drinks up there from what we're seeing. She'd be the designated driver. And then he had it in his mind that she would go back to his house and obviously take care of his kids. And that's what she thought. She thought that he left her. He just, he didn't care about his kids, about the kids that he has a guardianship over, and that she was supposed to just do it. And that's why she said, "I'm leaving, I'm going home." But she wasn't leaving and going home because the kids were there. At least one of the kids were there. My recollection is one had a sleepover. Okay. And so I think that she was mad because in the afternoon he had ghosted her. My view was that he had ghosted her by not picking up that phone. Remember, for hours that same afternoon. All right. He had ghosted her for whatever reason. And then, when he wants to use her, and this is what I think she's feeling. She's feeling anger, but she's not feeling anger to murder him. I mean, come on. I mean, that first count is so ridiculous. And we talked about it with Bob Bianchi last night, who's the former head prosecutor one of the major counties in New Jersey, the now defense attorney, and also an EMT. And yes, you had. And Bob was also interesting last night because if somebody says you hit him, there's national guidelines, and we're going to look. I'm going to look them up this morning for EMTs that they're taught about what has to be documented. And the first thing is the mechanism of the injury, because the mechanism of the injury is important to the treatment, right? The mechanism is so if somebody said, well, she said I hit him, then it's like what, with a baseball bat, with your arms, with your face. What did you use a tree branch? Was there a car? What are you talking about? Because that goes to the treatment. That's the first thing that they have to do once they get there. Once they find out that they're safe to go into the scene. So we're going to try to look up those registries. It was a national. Maybe you could in the national registry of emergency medical technicians, National Registry of Emergency Medical Technicians. So when he said that every state now uses this, they don't use their own guidelines. That every single EMT paramedic is absolutely does the same thing. Well, I'm hearing movement. I'm hearing sound in the courtroom. I'm going to go behind my keypad, and I
So I'm
will.
told counsel wants to see me as the jury's coming over. Why don't you come up to sidebar?
Well, I'm gonna say, well, I'm gonna be watching with you when I go behind my 2B app, my 2B avatar, by the way. You know, but of course, we begin the morning with the sidebar. I don't think she has what many judges have. You want to see me? You come in early. You come into my chambers. If we're going to start at 9, you come into my chambers 8:30 if there's any need to see me. And then when we go out, we'll bring the jury out. But obviously the defense wants to put something on the record. And I think it's an unusual way to have to deal with this case. Everything has to be on the record at sidebar. And there goes Mr. Lessie, Mr. Lessie, has grown on me tremendously. When he first came in, I thought, well, I'm not sure he has jury appeal, but he has really good jury appeal, and he's always prepared. And I hope the jury likes him as much as we do. Now, again, I'm going to say it's a mistake to underestimate Hank Brennan. He has tried a different case, and I think he's trying a good case, although it's a little bit disjointed. But what he's getting there is he's looking for a vibe. He's looking to have the jury believe that Karen Reed hit John O'Keefe immediately off the bat, and then he knows that there's going to be problems coming. But remember, the prosecution case is as good as it's going to ever get when they rest. And that's when people say, I hear commentators when I try cases that are high profile, oh, look at the prosecution case. But then when the defense starts, even though we don't have a burden, I'm a big one for putting on a case, um, even though we don't have a burden, but all of a sudden you see things being chipped away. And, it's not so clean and easy as a prosecution would make it seem. And what the jury may find, if they are leaning in any way right now to liking Hank Brennan, which was the text someone tweeted at me who knows about the courtroom, if they are leaning any way to liking Hank Brennan, if they find that he lied to them by not giving them the whole truth, let me tell you, that like is going to turn to dislike awfully quick. And the defense is going to be the ones, I think, have to call Proctor. I don't think there's any way that in my opinion, that Brennan's going to call Proctor. He says, I can prove my case. I can almost rest now, right? That's as soon as he gets a cause of death from his brain guy, the guy that's gamma ray surgery in Florida, who runs a brain clinic, because he has to go around. He has to go around all of the state people. He has to go around all the federal people, even though the judge won't allow the jury to know that these people were hired by the feds, that ARCA and this forensic pathologist they have is hired by the feds, which I think is a mistake. I think it's important for them to know who hired them, right? Because or else you're going to have the jury speculating. Well, so you were hired by somebody else. Well, so what? So what? Who are you hired by? In the first trial, they thought they were hired by Karen Reed's insurance carrier. Can you imagine that? They thought they were hired by Karen Reed's insurance carrier. So that carries a different weight when when the feds come after you. Because let me tell you, when the feds come after you, unless you're going to dismiss a prosecution because of the politics involved, and we've seen a lot of that recently, they generally have you. All right. I had one federal case that we were able to get a not guilty for our client who was accused of counterfeiting, basically because her family was counterfeiting, and then they were taking the counterfeit money and going to Atlantic City in New Jersey and putting it in all the machines. But there was they could not prove. My client even knew that the money was counterfeit. You know, your parents give you money. Here's a couple $100. Go play. Let's see, what should we say? Go play the come line on the craps table. All right, so or go put it into, here you go. You can use this. Get tokens. Go when they used to have tokens. This is back when they had tokens. Go put it into the slot machines. So she was not guilty, but the rest of the family were guilty. And I had another federal case that the case was dismissed without my client even having probation. But that's a different story. It's very hard to achieve those results in federal court, which I guess is why people hire me as a lawyer, right? They want to get the results. But you're only as good as a lawyer as the results that you get, because people like attorneys that get not guilty verdicts. They generally don't like attorneys that get guilty verdicts if they're going to hire them as a defense counsel. That's kind of like something you don't need an expert to say. So a great indication of whether or not Hank Brennan, after he calls his get around brain expert, who's probably making a fortune charging the feds. This is the crazy thing on insurance and on Medicare. Down in Florida, probably not so much on Medicaid. But his clinic's probably making a fortune on that. But they had to go find somebody who's good to get around their people. And I think that becomes important, because you got to get around your own people, unless you have somebody who really missed something, right? Unless you have somebody who really missed something. And when you're, and we've seen that. My husband's been hired a number of times to be brought in to look at cases where they felt the medical examiner didn't have enough experience to look at the case. And we saw one in Iowa recently within the last year where a man was convicted for murdering his girlfriend, and clearly the medical examiner, who was very lovely, said she deferred to him because he had more experience about how this person was killed. And the family was ever thankful to my husband, Michael. As you can see, he's involved in a lot of these cases. He's had a lot of experience. Now, when you're in the courtroom, you are only as good as your word, okay? Juries, if it's close, if they like you as a lawyer, will believe you if your word is good. That's why I say, if the jury feels misled, any indication that they're leaning or that they like Hank Brennan may go away if they felt in any way he misled him. And let's analyze this and analogize this. Remember Arca? Brennan came in and said he never learned about the payment. You never learned, Your Honor, about the payment of the $34,000 that the bill that is after testified. The defense, it was supposed to be given in discovery, and he said they didn't. Well, it turns out the defense had given it in discovery for the second trial. That's how the prosecution knew it. But by then, the judge had grave concerns that she had been lied to by the defense, right? So if we analogize this to that, once you feel misled, and it's clear that Judge Canoni wrongly feels she was misled by the defense, absolutely wrongly. If you get a bill after somebody testifies, the trial's already hung, it's going back, what do? You give it in the discovery that you paid in the next. But that doesn't mean you had a relationship. And then she put Arca through the hoops. And the problem I have with it, she did all this also in open court. And what did that do? Then you saw all the Twitterers and the keyboard warriors and the social media people. Oh my God, look at this. She's live. See that disgusting, scummy defense team. And I think that was wrong. I think that was absolutely wrong with her. And if I have to ever see her, I would tell her I would think that's wrong. All right. So why don't we, obviously something was put on the record about what's going to happen today, maybe about cross-examination, maybe an objection to the order, the Sandra Birch order. So I'm going to, as soon as they start talking again, I will stop talking. I'll be watching, I'll be listening. I have my AirPods on with the Tubi avatar. This is Karen Reed again. She's very, very involved in her defense. It's great to have a client involved in your defense. It's great, because you know what? If they get convicted, they're the ones going to jail. I'm going home at night and going to sleep in my bed, So you want a client that's involved and also agrees with the decisions that's being made and helpful with the decisions that's being made. It's not a bad thing. It's a great thing. For those that don't understand how cases are really tried. All right, so we're putting things away. I think we're waiting for the jury to come in, right? Is that what's happening? We're waiting for the jury to come in. We'll see where we start today. By the way, you know what's been missing from this trial? You ever seen Chloe? Any heard about Chloe? We're going to hear about Chloe. We're going to hear about Chloe probably from the defense. All right, but haven't heard much about Chloe from the prosecution. Chloe, the 7-year-old rehomed family dog of the Alberts, right? And also, by the way, on those phone calls, I had also different effects and all. And also, excuse me, I'm sorry, there was something on a case I had to look at. With Karen Reed, when she got there, and supposedly she said I hit him. I don't think she did. She said that there was something in there on those things that she said, well, Jen McCabe was telling me that John didn't come into the house. So when they played the clip, okay, that at the same time they were playing the phone calls yesterday, they were playing the two clips on the one on ID. She said, and so I thought, could I hit him? Because Jen McCabe was telling her John didn't come into the house. And so she started thinking, as we all would, well, then what happened here? He got out of the car. He went around the car. He was gone. No one saw him. He was gone. I went home. So to me, that was important because that goes with the defense theme that Jen McCabe told her that John didn't come in. And so now her mind starts going, oh, he didn't get into the house. Could I have hit him then? Could I possibly have hit him in some way? Because I have this cracked taillight. She didn't even realize she bumped into the car and cracked the taillight, which luckily we have that camera at John O'Keefe's house that was working and was pointed in the right direction, unlike the camera at the Chief's house on Fairview that apparently only points down to see if his Amazon boxes are delivered on his front porch. I don't believe that. Okay. I just don't believe that. But anyhow, Michel Bryant's going to go check it out. And as I said, he will be with us at lunch. He's doing his field trips once he gets up there first. And has a bunch of the other things and people he's going to interview. So he's going to be there today and tomorrow in Canton and Dedham. And then he may make a trip over to Stoughton too. So that's going to be, we'll let you know. This is why all sorts of things are moving in this part. But I just wanted to give you some of my thoughts. We discussed last night again on the trial last night on the show. If you get a chance to watch Bob Bianchi last night about what an EMT is supposed to be doing and what wasn't done here, please do. Okay, please absolutely do. Also, if I get a chance today, I want to play Microdots, who's given us permission. Put a thing about this did I hit him, would I hit him, all that kind of stuff for you, and I'm going to look at it again while the testimony is going on to make sure we can play it maybe on the break. So here we are, everyone's lined up. Now Massachusetts, I actually love this setup that the prosecution is up there at the judge, because you get to see behind the prosecution, and you both have equal access to seeing the jury. In most cases, the prosecution table is right next to the jury, and we always look to see where they're going, the wink of the eye, or looking at them and all. But I love this set. The one thing I do love is the set of Massachusetts, where the defense is behind the prosecution. They both have equal. The jury's behind that rail. You're not seeing the jury because they're this way. They're towards us on the bottom of our screen. But let me tell you, they're watching everything in that courtroom, and it's a tiny courtroom. Okay, yes.
I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
That's correct. All right, thank you.
Okay, so that's something that obviously wasn't discussed at sidebar. It's just redacted exhibits, and everything is okay. The jury is coming in. The fan is on right now. The fan is on because that way it's clear you can't show the jury accidentally, which has happened. It actually happened in my Hernandez case. I'll have another story for that. After you've tried a number of cases, you've kind of seen it all. As I always say, judges sometimes really should be stepping off the bench and sitting at the prosecution table. And in this case, even though Judge Canoni was a defense attorney for 24, 26 years, I think some of her rulings have been unfair to the
All
defense.
persons
All right,
having
let's
anything
go
to
into
do
court
before
and
the
listen.
Honorable Beverly Canoni, the Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, good morning again, counsel. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from...
By the way, while she's asking the questions, I'm going to shout over her. I will try to answer a lot of your questions when we get to them. Some of them I've already discussed. I see people that came in a little bit late, but we'll try to get to those questions.
We want to say yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
Good morning, sir. Follow me. Now step up, raise your right hand. Thank you, Clerk. Thank you.
Raise your right hand. Do you solemnly swear the evidence given to the court and jury in the case now and hearing should be truth, the whole truth, and nothing but the truth, so help me God? Yes.
Good morning.
Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the Academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes.
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to Gray Key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked to by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes,
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence. Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
With the court's permission, can he show the item?
Yes.
Thank you. Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
All right, any objections, Mr. Unity? Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who's collecting it.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that can be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
I just have to make a comment. All of a sudden, Hank Brenner's interested in the tape and the chain of custody. That's once you get into
Sir,
the
on
bag
those
and the
items that
chain
are
of
stickers,
custody,
did you put the stickers
how
on
did
them?
it get there in the first
did not.
place?
Do you know where the
Okay.
stickers come from?
Taking that little note. I'm still with you.
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces, or is there another piece in that bag?
There is another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the two bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay.
Okay. Now the objection came really interesting. Could you talk about the other two pieces? Objection. Can I be heard at sidebar? And it's David Yannetti who is taking the cross-examination of this witness. And then there was the objection. And that's when Hank Brennan wanted to move these two pieces of tail light into evidence. And I think that it's going to go again to the chain of custody. Now, those of you who have followed our show, okay, know and Louise P., I will get to your question in a second, know that I've shown you the computerized forms that they use in Massachusetts. Everything is logged in. If you breathe on a piece of evidence, it's supposed to be logged in or logged out. That's how we were able to find out in Hernandez where things had gone. And no, this case doesn't have those. It doesn't have that. So you can have a chain of custody once you put it into the bag and tape it and then untape it and tape it again because the lab uses it. But it's beforehand that's important. And Joe Giacalone on our show on Monday night talked about that. So they just made their objection for the record. Okay, here, that's
So,
what's
Mr.
happening.
Brennan, I
Judges-
leave it to you and the witness how you do that part.
Yes.
Okay, so we're going to deal with that in a cross-examination. Obviously, the judge
Sir, on the
likes
small
Mr.
chip piece, you
Yannetti.
don't know how it became chipped?
I do not.
I'd ask you to remove that chip. Like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And then I'd like to introduce that exhibit.
So we're going to mark the little chip.
You want-
Mr.
you'd like to
Yannetti
mark it?
asked to
Okay.
mark that. Yes.
Then we're going to submit that for identification. So the
Okay,
small
now we
chip
just heard
will be extra
Yannetti
secure.
asked to mark
Madam
the
Court
chip.
Reporter has an envelope for that.
Thank you very much.
Okay, so that's going to be marked, and so he won that.
Thank you.
This is going to go to the chain of evidence and the chip. This is going to become important. Let's mark this now. I'm going to have you all put a big
Thank
X as to what we're doing with the chip because this chip is
Trooper, we have
obviously
one more
important
bag
to
of
the
items to
case.
go through.
Yes.
Could I have Exhibit 73, please? Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
If I'm showing you a photo, you recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
Okay. There's no objection, Mr. Yannetti?
There's no objection, no.
Exhibit 79.
With the court's permission, could we show Exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please? Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, trooper. I'd move these items into evidence.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Mr. Yannetti?
Please, Your Honor, thank you. Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself?
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well?
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022?
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach you, Anna?
Yes.
And I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the.
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No. Not a homicide investigation, no.
You have not yet.
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
All right, so we're starting to inch in with the Proctor factor, okay? Oh, he's getting a little nervous because I think they've all been told to try to stay away from Proctor, right? Now, Louise, do you think Hank is a good lawyer with no ethics and morals? No, I think he has some ethics, okay? But he dances the line, and I think sometimes he crosses it. Now, when you representing people like Whitey Bulger, you kind of, I think, get that. But he's very technically good. He's very prepared. And my point is that you can't underestimate him. He's got a lot of experience, all right? So that's my point, Louise P. Don't underestimate him, all right? So here goes Unetti back. I remember when I used to take my computers that people thought I was like crazy, but now this is what we
Interviewing
do.
Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach, Your Honor?
Yes.
I mean, come on. You don't know who you interviewed. He didn't refresh his recollection on some consent form. By the way, I don't know why they're redacting consent forms, all right, before they put them up on the viewer. Maybe because of signatures, and they don't want duplicative signatures out there. They don't want people to electronically grab a signature. So that's the only thing I can think of. Certainly the phone number, maybe the phone number if it's still current, that could be redacted. But usually I haven't seen a consent form redacted and all. But this thing where he doesn't remember interviewing a main witness, not a main witness, but a witness. So I guess everybody's a main witness these days in a case. You can tell that he's staying away. You don't lead trooper Proctor. I don't recall. Come on. I mean, really? All right. So let's see if he reads.
I've placed a
refreshes his
document in front of you.
recollection.
I just ask you to read that silently to yourself. Look up at me when you're
He
done.
didn't even read it. Boop, boop, boop. I'm waiting with bated breath here. Our great producer, Missy Mayhem's on the chat. Okay, so she's running the stream for me, so I can do this for you. Oasis Cat is on the chat. Yeah, it's funny. To us, it's so normal. As a matter of fact, we assume everybody knows these things because this is our profession. This is what we do. So, we're just assuming that you all know. Now he's reading it. Before he was like, oh, now he's reading it. And he's like, what? I did an interview. Okay. Proctor was there. With Proctor starting to raise his head.
Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take a look, sir.
Go ahead.
Now he wants to refresh. Okay, we're going to refresh. I love it. All right. And after Unetti says, I'm not going to ask you specifics. Yeah, Unetti's just going to point out that he interviewed Sarah Levinson with Proctor. So now he's reading it. So this is something that he had not seen. This is something that he had not prepped for. And when they had to go off script, because they are very preparedly coached.
Having
as to
reviewed
where
that
you're
report,
going.
does that
Okay,
refresh
let's
your
go.
memory as to
Lessons.
whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes,
Okay. And the two of you would have participated in that interview together, correct?
yes,
But you did not write the report, correct?
no, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input, you weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. Let me approach Judge.
Yes.
Thank you. You're welcome. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. You, or asking you this, you retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes,
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure.
This is a brilliant way to get Proctor's name before the jury. This is brilliant. You see, he's nervous. You see that little thing, and the drinking of the water. When you're trained to cross-examine, when you see people looking to aerate their collars, witnesses looking to aerate their collars,
Let me approach.
to take a bit of water. Usually, when you see that, that means they're nervous. Whoop, here we go.
I'm sorry. And again, if you'd read that silently to yourself and look up at me when you're done. Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I
Right.
did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes,
And that, by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
this is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the Waterfall Bar and Grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes,
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
Okay. Does anyone remember what Trooper DeChico's nickname is? Because obviously it led to an objection. Quick sustain, quick. And obviously we're going to sidebar because we're going to either argue for it or we're going to make a record. So can anyone tell me, look at your Twitter, what was Trooper DeChico's nickname that caused this objection? Oh, really? Oh, and now I am certainly piqued. And quite frankly, if I'm on the member of the jury, I'm piqued too. Like, why can't I hear the nickname? Is it something bad? Come on. This is amazing. But he is making the point that Proctor's the lead investigator and also Yuri Buchanan has come up. So let's go into court. Let's listen to what happened here with this objection and this sidebar.
Trooper, in terms of the troopers that were in your unit as
Obviously,
of January 29th,
Yannetti lost that objection. So we got to find out. All of you find out from me what the Chico's nickname is.
In the unit at that time.
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as
Ooh,
of
then
January
Trooper
29th,
Michael
2022,
Proctor.
correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
Oh, really?
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
This is very important. This is actually very
What, if any,
important because this is a big issue in
conversation
forensics.
did
I'll
you
talk to you about it after.
With Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment.
So we're going to look at the report. Now, clearly, it's important because it's a big issue in forensics now. When the police come in and tell the medical examiner, here's what we think
May I
happened.
approach, Your Honor?
There's a condition of like, are you going to then be biased as a medical examiner and look just for that? And it's been a big argument in the forensics world that the police should have nothing to do with the theory of what the medical examiner does. That should be basically based on science and
So I've placed
not
another
have this
document in
theory
front of you.
in
Just
front of
take
them.
a look, read it silently to yourself, and look up at me when you're done.
He's looking at the autopsy report of John O'Keefe since he was the only trooper that attended the autopsy report. I think Yannetti, the
I
jury
would direct
kind of
your attention
knows
to the
that
second
Proctor
page
talked
for
to
the question I just asked you.
Dr. Scorty Bello, anyhow, but they don't understand the significance of Proctor yet. They do not.
Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
He's not prepared for this. This is
Yes.
interesting. This is the first witness who's
Now,
not really
was this
prepared
the
for where
first
Cross
autopsy
is
that
going.
you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when
This is
you left that
ridiculous,
Dr.
sustaining this.
Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorty Bello had seen the injuries to John O'Keefe's arm.
Object to the line of question.
Sustained.
This is ridiculous.
May we approach?
Okay?
Absolutely. This is ridiculous.
Feel free to
Okay.
stand up.
All right. Rant. Stand up. Let's rant. Okay. The troopers leave. They want to know, they're there at the autopsy because they want to know what the medical examiner and forensic pathologist is finding. So that guides their investigation. Did she find that this was a homicide? Did she find that the manner of death is a homicide? Remember, there's causes of death. That's what caused the death. In this case, it was the fracture and hypothermia, right? And the manner of death was left undetermined. Manners of death. It can be homicide. That's not murder. It's death at the hands of another. Accident, suicide, natural, and then there's undetermined. Okay. So you really have the four that are the causes, the manners of death, and then the undetermined is the last. NASH system, it's called NASH. Okay. And it's absolutely, it's important to the officers when they leave. That's why they go to get in first of all, to tell the medical examiner what they know and on their investigation so far. And when they leave with the information from the medical examiner, and it guides the investigation or an arrest or whatever. So to say, to not allow this trooper to testify as to why he was there, what he told her, what he knew that he didn't need to tell her because somebody else had already told her. And by the way, that's not for the truth. That it could be for the truth, but let me tell you, it's really not for the truth because you're not saying what the investigator said to her is actually true because they have a theory that may be not true, right? And then when you leave, you're taking that information because it's gonna affect you as to how you guide and what you do. So these objections are outrageous. But what's more outrageous is the fact that the judge is sustaining them. That's what's outrageous. This is where I have a real problem with this case because everything the defense does that's normal, allowed, would be allowed, clear, used in other cases, what we do as defense attorneys. This judge who was a defense attorney is objecting. She has a real hard ass here for the defense, starting with Alan Jackson. And it's becoming clearer and clearer and clearer to me. And this is my rant, okay? You know that sometimes I go on rants. This is my rant, okay? Let's go back in and listen.
Were you watching Dr. Scorty Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
Objection.
It's the same
What?
thing. Just
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Oh, wait.
Was she looking
Okay.
at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do that,
the body.
I'm sorry?
She was looking at the body, I assume.
Oh,
I'm not in.
now we
Thank
get
you.
it out.
And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
I know,
Yes.
Oasis,
And
you're going to want to put
it
my
was
rant up
at
right
the-
now
the-
on
the arm was not
on
covered
X,
up
aren't you?
during the
Because that's
autopsy,
my rant.
correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
He doesn't know how to answer
You
it.
didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
Correct.
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts
Oh.
is giving input, is it not?
It's not input.
Okay. Did you talk
Just
to
the
Dr.
facts, ma'am.
Scordello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
What? What?
No, none, thank you.
He has to know what he left with because that frames what he does with his investigation. And she objects to that when you know you're going to tie it up with the medical examiner.
Where's this break we're going to take now?
Taking a break. That's another rant. All right, she's now taking a break at 10:07.
All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take. and it's a
The
little bit
lawyers and
longer.
I have work that we have to do.
We'll take a recess.
I think
after
there's
the next-
going to be some objections on the record.
I want counsel to stay.
All rise for the court, please. Close your notebook, follow me.
This is, I can't wait because we're going right back in the courtroom because she wants the lawyers to stay. She's pissed at the lawyer. Why? This is perfectly good cross-examination. You left without a call. And normally the judge would say, counselor, are you going to tie this up by bringing in the medical examiner on your case? Yes, we are, Your Honor. Okay, I will allow this testimony. This is how it's usually done. I mean, the fact that the medical examiner called something undetermined, she's going to rule hearsay? What are we talking about? Okay, this is why everybody is so angry at this case. It's one, they don't think Karen Reed's getting a fair trial. And what's happening here is that there's a whole dinner.
So I want to talk a little bit more about what we talked about at sidebar. And
let's hear this.
I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice.
Wish she'd be on the mic.
Require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall.
It's an SJC case, so yes.
Yeah. Okay. So now to the Maryland case. So that's governed by federal Massachusetts Rule 39A, and that is records of courts of other states or of
Excuse
the
me,
United
2B is
States. The
waiting.
Act provision is the records and judicial proceedings, and of course a court is judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent.
I'll explain what
evidence,
this
it
is
shall
after
be in
the seal.
evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor, in the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to
I don't know what the case
put in
is,
a
by the way, that he
qualification
wants to get in to have the judge
when they
put into
introduced
evidence.
materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it one
The
area.
decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
What is it that, so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking
If I could
me
proceed
to allow.
and give you the answer, Your Honor, I
Go
will
ahead.
explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the
Great argument here.
I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not
It's a
relevant to what
judge's
she can
decision.
testify to or the basis for her opinion. It is not a law. that is
Malign
admissible.
a witness.
It's an
Okay,
opinion. It
let me
wasn't
put
even
this
about
down.
a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody
Well,
has
you
the
guys
Apple
got to go out
source
and
code. No expert
Google
can
this
testify
opinion
about
for
Apple
me
source
while
code.
I'm on the air.
It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, what,
It should
number
be
one, what he says,
cheapened.
I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location.
Somebody
Although she
Google and
looked at
find
it,
me
it's
this
not part of
case.
this opinion whatsoever.
Jessica
So because
Hyde,
another court
Maryland,
didn't
digital
allow
little
something
forensic
under
examiner, source
has nothing
code,
to do with this
unreliable.
case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did
227.
not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp.
No, that was raised, but this.
What is she going to say? If you don't raise it with one witness, you can't raise it with another?
The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor.
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph.
I wish I could hear some Valero
the
decision.
reliability of an expert's methodology. I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion,
Go, Alessi.
the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized.
Oh,
To use
give me a
term
break.
to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with a timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics and the court says that issue is not admissible,
I need my
this will be
keyboard warriors to
when they
find me
go and
this
talk about
case.
a
The Maryland
totally
case
different
called
issue in
Ferreira.
forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Miss Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled, it's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness.
This is, by the way, a brand new case that came out of Maryland in March.
Methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Galbertize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross.
Remember I said good attorneys don't back down? This is it. We're not backing down.
Of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert, and this is how they're going to distort it, invoking the Constitution and invoking the client's
Invoke
rights.
the Constitution distorts it? Give me a break.
Totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related.
You know, normally I'm silent during these court hearings, you can hear.
If a
But I'm so
reconstruction expert went into a
outraged.
court
I'm feeling your
and attempted to
outrage.
give an opinion about
I know
a
Missy has to
medical
lower my volume
diagnosis,
because I'm
and the
so
court wouldn't
outraged.
allow that medical diagnosis in another court, in another jurisdiction, they would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case. And even if it wasn't, it shall be in evidence. So there's two issues here. And I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says, ipso facto, yes, as long as I've got a certified copy. So it is in evidence.
That's why he has the seal from the state
whether I can
has to be
question her on
certified.
something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He is going to include, he has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't, in anticipatory, have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
Right, and Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this. If they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls, but if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence, but not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be, that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in.
Noni knows that, unless he
And
knows what
they
he's talking
shouldn't
about.
get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here?
Your Honor, may I ask one thing? May I, Mr. President?
I just want to know, is she here?
He is, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Okay, we have some drama, and it's perfectly great drama. It's legal drama. It's Alessi arguing perfectly wonderful things. A new decision has come out in March. We're going to find it. I'll have to find it when we have a chance, okay, when they go to testify. She's the next witness, apparently, this Jessica Hyde. That's what's triggering this right now, okay? And the judge is like, well, you give me more notice. Well, if a good attorney finds something in trial for trial too, and he's not saying we need to do a Daubert hearing on here, which is what the judge is going to try to say, well, you should have raised this issue with a Daubert hearing. No, because even if you lose a Daubert hearing, you're allowed to attack the witness's methodology. That's Jessica Hyde. Recall, she was the one who got up and said that this was a tab search, blah, 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 and it wasn't deleted because it was made in the tab and all that type of stuff. Another court has found the methodology she uses, because she doesn't have access to the Apple source code, unreliable in how she determines things, which is no one else is determining things. And Hank Brennan says, this is what pisses me off. Okay, now this is what pissing everybody off, and I know I keep telling you, you can't underestimate it, but you can't underestimate it because of things like this. He says, this is the defense's attempt to malign a witness or dehumanize a witness. No, it's the defense's attempt to get the constitutionally right fair trial. And then Brennan attacks the Constitution. He says, by using the Constitution. You know that Judge Canoni is concerned because she doesn't have an answer. She's going to go try to find an answer that's going to limit the defense. I can tell you that right now. Whether she has Jessica Hyde come back tomorrow or whatever. But what he is arguing is, number one, the decision should be evidential, right? Because he's got a seal under the Massachusetts Code. If you have a court document that's under seal, that means it's certified by the court. There is also another way to have certified and validated in a different way too. But I don't think she's going to allow that. I think she's going to say, well, you can cross-examine her maybe on another court. But I've seen experts cross-examine on opinions in courts all the time. Other courts have found them unreliable. Come on, give me a break here. This is outrageous.
Goodbye.
Goodbye. Is that saying goodbye to me? I think they're saying goodbye to us. I think she's now taking an actual break, all right? This is the real break, all right? She's taking this. Yes, she's taking this under advisement. She may need some time. She has to research the case. She has to look at it. And she's got to find a way, in my opinion, to blame the defense for not bringing it. And Leslie says, Your Honor, this is a new trial. Because it wasn't trial number one, so what? So what? This is a new trial. We're allowed to bring evidence in trial number two. This is a new trial. I wasn't here. I mean, it's and you can see that she's working her way to try to deny the defense to do this. She may split the baby. She may say, I'm not allowing the opinion in, but you can cross-examine about her methods and whether they have been found reliable in other courts, blah, blah, blah. But it doesn't have the same effect in front of a jury if you know another court has rejected her Because she can't get peer reviewed. Why? Because her methodology is wrong. Why? Because she's doing something basing on the source codes, unlike the other witnesses, of Apple, which she doesn't have. Matter of fact, nobody has the source codes of Apple. Okay, so this is really ridiculous. I have grown to, initially I was a little bit like, okay, I'm not, as I told you, I'm not sure unless he's going to be jury friendly. He came into Dr. Russell and all, but not only he's he jury friendly, when he speaks, she knows that he has everything, and those were those papers he was carrying up to the bench, and I think probably maybe that was what they were dealing with on the day, because they had noticed that the Commonwealth was planning to call her. Remember, we saw him go back and he grabbed two hands of papers and all. He knows what he's doing, and behind the scenes, he's done all this. So she's going to find a way, I'll guarantee, to try to reject that court opinion coming in as evidence under the Massachusetts rule. All right. But I have to find the case. I mean, I have to find the case. And the problem is I can't look for it while I'm here on with you. Herrera is what I thought it said, Herrera or Harrara. I don't know, because he didn't spell out the name of the case. We just know it's a superior court case from the state of Maryland. It should come up if anyone has access to Westlaw or has access to Lexis, and it may come up on just a regular Google search and all, because I really would like to read the case. But to have Brennan come back and yeah, if he wins this, though, what do you say? Well, whatever argument he put before the court, it was allowed. Now, remember how Arca was treated by both the court and by Brennan? Remember how Dr. Wolf was treated on cross-examination? You don't think that was trying to be dehumanizing? You don't think that was trying to be snippy, snarky, rude, bullshitty, nasty? And the judge did nothing about it. Nothing about it. But here, Brennan's like, when he says, and he knows he's losing, right? He thought he was losing the argument, because he sees that she is worried that she may let into Massachusetts an expert who has been rejected by another court. Maybe not on a 227 stamp, but that she was using the 227. She has to use some location data. And Brennan was saying, well, it's not much location data. It's not the same type of location data. It's location data in an extraction. Oh, yes, I am shouting. Okay. Yes, I'm having my second rant of the day. For an attorney to get there and say, because, and Alessi was very, very, very good. He said, Daubertize, okay? And according to, yes, somebody put in, look at how he treated Dr. Russell. Look at how he treated Dr. Russell. But to malign a witness and then dehumanize a witness, well, if anybody tries to dehumanize a witness, it's Hank Brennan, all right? Maybe that's why those words come up with him. Even though, I will again say, he's a very good attorney, because, look, he's got a client, he's going to fight for the client, and he's going to do whatever he needs to be done, and it's fighting for the client. And unless Morrissey says, hey, that's out of bounds, no. And you see, even let's go back to even before this, because this has taken us, the previous trooper that was on the stand, Keefe, right? He didn't want to answer. As soon as they get out of their comfort level where they've been prepped, they're like, notice how they're like, they don't want to answer the question. He didn't want to answer the question about what the medical examiner and whether or not the proctor had told them their theory, whether or not he had a theory. She sustained an objection to say, did Doctor was Doctor Scornibello looking at the body? Objection. Well, then Yannetti had to say, where were her eyes looking? This is ridiculous. If she's doing the autopsy, of course she's looking at the body, and of course this trooper is seeing her look at the body. What are we talking about here? What are we talking about? I have to calm down. I know it. I know you want me to calm down. All right. But what are we talking about with that? I mean, and then when you left the office without a manner of death, objection sustained. Yes, he was there to give input into what he's seen and to get the and my husband, I wish I could get my husband on this, because they want input, the cops don't want input from the medical examiner to know what it is that the medical examiner is finding, and they can see it, and what the medical examiner then tells them. So in an objective investigation, they will then go out and rely on what the medical examiner tells them to continue their investigation. If the medical examiner says this is a self-inflicted wound, like, let's see, the Birchmore case, then they don't investigate, right? But if somebody says it's a homicide, then they go and investigate. It's common sense. We see it on TV. We see it around us, but it's common sense, okay? I mean, give us a break. Give us a break on that, okay? I just couldn't believe, quite frankly, I couldn't believe, but I could believe what I was hearing because I have been so busy, as you know, trying to defend Judge Canoni because it's a hard case. But I think these rulings today are pretty outrageous. I mean, these rulings are pretty outrageous. So when Scorty Bello gets on the stand, what she can't say there was a trooper there, and what did you tell the trooper when he left? Objection, hearsay. That'll be the objection, okay? Because now we have no one who could tell anybody what was going on. You can't even say as a result of your conversation, which maybe you shouldn't be doing. As a result of your conversations when you left the medical examiners, did you believe you had did you believe that she was called this a homicide? That probably was a question that may have flied by, no, because then it goes to what the witness believed. Did you believe you didn't have a manner of death as a result of the conversation? Yannetti could have asked that. He didn't. Let me say it again. As a result of the conversation you had with Dr. Scorty Bello when you left the medical examiners after the autopsy of John O'Keefe, did you believe that the manner of death was undetermined? That question was not objectionable because it goes to the hearer's intent, what the hearer believes after he has a conversation. And I have to say, Yannetti didn't ask that. Okay, I think he was so. I think as we get in these trials, sometimes we're so, I can't believe what the rulings are on the sustaining that you don't think of that simple final question. Because remember, I told you there's always a way around, even if you're circling the wagons around. Okay, Missy's not finding the case. I'm going to have to go probably on obviously it must be on Lexus or you know what happens in these cases when there's high profile? You're a defense attorney and you'll get a call or an email from somebody and say, look, I had that witness on a case and the judge found her unreliable and here's a copy of the opinion. Maybe the opinion is not reported. Maybe it's not a reported opinion. We don't know because there was no cite given. Now that I'm thinking about it, maybe it's not a reported opinion in Maryland, although I'm not sure how Maryland works on reporting opinions. So let's see if I could go down and start and answer some of your questions. By the way, I have to tell you that we've had complaints that we're too juvenile when we discuss these cases. I don't think we're juvenile at all. We're not going to use the sound effects unless it's like really, something that's kind of fun and we can play with it to give you all a break, as we all do in things that are serious. Sometimes we have a little bit of humor. And Michel Bryant, with his demonstrations, he's doing those as demonstrative exhibits, right? It's almost for you. This is chalk. This is chalk for your value. We're not in court. Our chalk doesn't have to be perfectly appropriate. It just has to be valid. So if we go out and buy the tail light from the Lexus SUV and we crack it, we're going to use that, okay? We're going to use that. Absolutely use it. And if you think it's juvenile, I'm sorry, but we're going to use it. So just want to let you know. But we are sorry if anyone feels offended by us. And I want to get that on the record. Offended by us in any way. We don't mean to offend anybody. We love you all. We love all of you that are coming here. You have made this channel grow, and you are just an awesome, awesome group of subscribers and followers. And by the way, I have to say, of course, you have to hit the like button if you're watching, please, the subscribe and the share button. If you hit the subscribe button and you're just lurking on the outside, you can come in and chat. Okay. All right. So ARCA is my kryptonite. FBI has a way of getting info normal agencies cannot. I'm sure they're collecting the info on the judge. Well, they're certainly collecting the info on this trial. I know that there's been, what the investigation, whatever it was supposedly closed. but we don't know what it was exactly. What, it may have been a very limited investigation. It may have been an investigation limiting to the way Canton is related to Staunton, because we know about the Sandra Birchmore. So we don't exactly know the frame of the investigation. We know it had to do with, obviously, what caused the death of John O'Keefe, because they went out and hired ACA. Maybe that's simply it, or did it limited to that? Did an SUV or a car strike cause the death of John O'Keefe? And their experts in the FBI came back and said no, and they have access to the best experts, and also they can pay the best experts. It's very hard unless you have a client who's extremely wealthy, or you have a client who the public wants to support and fund and give money to. It's very hard to mount a defense, because most people don't have the monetary resources to mount a defense against the state, and so the state overcharges on these cases. They put you in fear of mandatory minimums, and they force pleas on people that are not guilty. And we've seen how many not guilty people there are that almost went to the death penalty. They almost went to the death penalty, maybe 3 hours away, 6 hours away. But we see it because of the Innocence Project. So we know this happens, and we know a lot of experts have put them there. Bite mark experts are responsible for a lot of the wrongful convictions. The Innocence Project has a whole section on that. Bite mark experts that identify a specific person's bite. A very specific bite. You can do a generic, but you maybe not be able to do a specific. Although, as you know, we had Chris Fabricant on from the Innocence Project who explained to us he doesn't even think that's reliable. Okay, Dina Hill, you love Alessi. I do too. Johnny Fayette, Donnie Nados, but be careful. I and Dr. Biden met during an autopsy. Best story. It's true. We met during an autopsy. We actually based our Remain Silent novel that we wrote like 15 years ago. Before actually there was Twitter and social media, we had two crime thrillers out, Remain Silent and Skeleton Justice. And we kind of used the basis of how we met as the basis of the two characters in that book. Okay. Just so you know, yes, we did meet during an autopsy. I can't make those things up. All right. Longer story, maybe sometime we'll tell it, but I think you can probably find it. I think that it's even been written up by a number of different people. Okay. Quit interrupting Bev. Is that me in Sunshine Cheryl? Was I supposed to not interrupt Bev? I'm sorry if I did. I couldn't take it anymore. I really couldn't take it anymore, because I've been a defender of hers and trying to be respectful. And I still will be respectful to the position. I'll still be respectful. But I think that her rulings have been wrong. I think that her doing, as I said last night, all of this in open court against the defense because she thought that somehow they misrepresented to her whether or not ARCA was their witness was wrong. I think that if she had those concerns, it should have been in chambers and sealed so that she didn't have that. But now we see that, she's got this thing with Alan Jackson. There's no doubt about it. She finds her guilty of Rule 14 discovery violations before she even has the witness in on the hearing. Remember? Wolf came in on the hearing because she already found them guilty of discovery violations, all right? But then allows him to testify. Why? Because clearly there was no discovery violation, all right? Oh, my goodness gracious. Missy points out that, in case all of you know, Jessica Hyde was the digital forensics examiner that they brought in to say that the hospital to die in the cold wasn't made at 227 because she had a new theory that it was made with an open tab that was kept open, all right? But you could have had a tab that was open. You could have opened the tab, made it, and deleted that search, and then your follow-up searches could have been on an open tab, even if you buy into her theory that that's how it was made. Celebrate. Everyone wants to kowtow to the state because that's the people with the money. They hire you all the time. And let me say that Celebrate, as we know, with Mr. Whiffen, went in and used his own little program that he sells and he works with Cellbrite on, to change their program to get rid of the search that the Cellbrite that was in it. And that other Axiom and other people still find that 227 search made it 227 by McCabe and then deleted. The only thing on that day that was deleted. Okay. All right. Yes, Gainer Rands, I love Alessi. I think we've all grown to just love Alessi, and I love his. By the way, his daughter's in Twitter, ex Twitter. If you go find, I think her name is it Jessica? Is her name? I don't remember. Missy, do you remember Leslie's daughter's name? I know I follow her and all, but she is so obviously so proud of her papa. It's great to follow her. And I think Alessi now is on Twitter also. At least somebody who says he's Alessi is on Twitter. He's got an X account, I should say X. I use Twitter because when you say you post something, if you say you tweeted it, people know exactly where to go. If you say you X'd it or posted it, then you got to say, well, I posted it, but I posted it on X. It wasn't Facebook. It wasn't, something else, at all. All right. Um, uh, Donnie Osmond, I'm 100% confident Dr. Bada was charming. My husband is very charming. He's an old school gentleman, opens car doors for women, opens doors for women. I always say that they don't make them like they made him anymore. Yes, he is charming and all. And that's why he's good in front of juries. Prosecutors hate him when he goes against them. And then they try, if you want to talk about it, demean and dehumanize, but he knows what he's doing, and I would trust his opinion on anything over anybody else's opinion, no matter what, because you see how many cases he's broken open and solved as a matter of because of his expertise. He's seen it all, and he has so many autopsies under his belt and all. So, Kathy Bennett, I want to see you in court. Yeah, I'd like to have somebody try a case with me, but everyone wants to either settle with me or whatever. You don't get that many trials when you're in private practice after a while, especially when I did a lot of trials and I kept winning them in federal court, especially a lot of civil trials on discrimination and civil rights work. That's also what I do. And then people just want to settle with you. They don't want to try cases against you. So that's what happens when you get to the point I am at. Which is fine. I mean, as for my civil clients, it's wonderful. Last year, I was able to get a family who was in England and California and couldn't get any resolution of anything, and we were able to get them actually a large settlement involving two fully throated insurance policies without ever even filing a complaint. But that's partially based on your reputation and what people are knowing that you're doing. So it takes up a while to build that reputation, and also the respect from people that they like you. Now, internet trolls will hate me. I represented Casey Anthony. I did this. I did that. Everyone's entitled to a good defense. I want to make sure this system works. I want to make sure. Look, if you convict the person and they're guilty, go to it. Do I want to see people that I think are guilty convicted? Absolutely. And most people I think that I've talked about, I think are guilty. But I think in this case, there's a real problem with the burden of the proof beyond a reasonable doubt. That's what I'm seeing. And if the juries want to take the simple way out and say she's guilty on count 2 because she was drunk, she drove a car. Look at those text messages. She drove an SUV. No one saw him alive. You believe the prosecution, the witnesses, if you believe them. And therefore we'll take the easy way out. We'll find her guilty. Well, that's the easy way out, but that's not the constitutional way out. But that's why the defense is fighting so hard. Yes, Candy Temple, to say dehumanizing, I thought was so terrible. Brennan dehumanizes almost everybody that comes under him to be cross-examination. Just terrible. Okay. I can see you all hate the way you treat the offense. Love how Alessi fights. Yes, us too. I don't know how they got Alessi. Obviously, they had some recommendation. Maybe Alan had some dealings with him in New York because Alessi was not a household name. It's not the name you'd pick up and you'd call if you had a high-profile case right off the bat. You would never think of a Robert Alessi. So obviously, he had some access to him. He kind of does the stuff I do a lot in court. I like to concentrate on the forensics in court, on the science, on this type of stuff that he's doing. I love this stuff. I find it fascinating. I could listen to it all day. And when I listen to it, I learn. And the reason why it's important to learn is so that when I can cross-examine a witness, I know at least a little bit about the witness's language. Maybe not in that case, but maybe in another case. I talk about my partner who taught me about making sure you do everything so you understand. he had a case involving when we used to use photocopy machines, right? Xerox machines. I think it was a Xerox. He actually bought the like model, just like we did with the lamp and the light SUV light. He actually bought the model and he took every single part on the photocopy machine, so he knew how to cross-examine this expert. There was only one problem: when he put it back together again, he had one screw left, and he never knew where the screw went. But it obviously didn't affect the machine. CM Laval, damn, Brennan, Constitution keeps getting you. Wow, I couldn't believe he said they're trying to make it almost trying to make a kangaroo court because they want to use the Constitution. What are we talking about? All right. Yeah, I mean, come on. Yeah, invoking the Constitution. What? What? Yeah. How dare the defense invoke the Constitution? How dare the defense make the state prove their case beyond a reasonable doubt? How dare they do that? That's what Brennan was saying. But unless he doesn't back down. Now, we had an issue in Massachusetts when we tried Hernandez. The judge did not want me to do a demonstration in court, which we had found the like shirt of the decedent, and we wanted to show that the angle of the wound could not have come from where my client was sitting. That was Aaron Hernandez in the SUV he was in. SUVs seem to be in every case, right? And the judge initially said I couldn't do it. Well, let me put it, we had a sidebar from hell, and then we had an argument in court, and you know that we backed that judge down, and he let us do exactly what we wanted to do because we were right. And we also had another issue in court with a judge where apparently he on Hernandez. That was one involving me. We had three issues, and we just, you have to be able to stand up for the judge, and you have to be able to go to jail for contempt, by the way, if the judge doesn't like how you're speaking to them. Where apparently the judge said something, and I don't remember what it was. Jose Baez was in the case, Ron Sullivan and myself. We were like three co-chairs of the case in terms of how we did it. Jose was lead, and Ron and I were we all split. We had a third of each of the examinations and the case. And actually, I was running the war room. The war room was rented at a place, and that's where my sleeping quarters was at the war room, where all of our staff was at that time. But Jose got up and actually yelled at the judge and said, "How dare you demean me in front of the jury? If you want to demean me to my face and here, fine, but don't you ever demean me for the jury." And the judge apologized and then gave the jury an instruction to cure what the judge had said. That was the second time. And the third time that we had to get up in court was with the picking of the and make a record, was with the picking of the foreperson. Now, in Massachusetts, the foreperson is picked by the judge. That's by their rule. The judge picks the foreperson. Now, who do you think a judge is most likely to pick? I always believe it's the person she believes is going to convict. He or she believes is going to convict. And we had a very integrated jury in Massachusetts in the case we had. But we had one white Caucasian female, and that's who the judge picked as a jury foreperson. And we thought it was outrageous. And also, she was the one who was probably, we thought, the most, prosecution friendly is what I'll say. Prosecution friendly. Turns out that and voted not guilty. We had a 12-0 decision on the not guilty on the two double homicides for Aaron, where that jury already knew that he was convicted of a homicide. And we had to stand up in court, and we had to make the argument that we believe the whole idea of picking the judge picking the jury foreperson, especially if they're picking somebody who's the only person who's white on the jury, was unconstitutional. But we fought it. Of course, we lost it, but we made the record, right? And you see now that has also raised its ugly head. In the first trial, the judge picked somebody who was a former cop. Now, why do you think she picked somebody who was a former cop? Of course, I don't understand why the defense let him on. My view is you are never letting a former police officer on when the issue of whether the police officers are crooked or have phonied evidence is before you. Just the blue line just runs too deep. It's in people's DNA once they're in law enforcement generally. So I think that was all that, if I have to say that's a mistake, I told you, I give you my honest opinion. I think that was a mistake by the defense picking that jury a foreperson, because it gave the judge the ability to then make that jury, that person, the foreperson. And he apparently was one of the ones that was writing all those long notes, right? But then may have been one of the ones that hung the jury for a conviction on count 2. I don't know that, but that's what we're hearing. Okay. Um, she's going to take it under advisement. Yes. Brett, Simi Sharp says Brennan is triggered. Sounds like that was the first time I thought he was, because every other time he gets up there and he is pretty sure, but he could see that the judge was concerned about Alessi's argument. He could see that the judge was concerned that she may have to give him something, and that's why he went off the rails there with they're trying to invoke the Constitution, dehumanize my expert by invoking the Constitution. No, they're trying to show that your experts, excuse me, full of hot air, because what she's doing, she doesn't have the tools to really do what she's doing, to make what she's doing reliable. And that was the key word, not just credibility, reliability. And even if you lose a Daubert hearing because the judge finds that as a matter of law under Daubert, you have enough to make those 5 standards, 5 proofs, in terms of is your methodology reliable? Has it been peer reviewed? Well, obviously, we're learning that she doesn't have peer reviews in a lot of things that she does. Peer reviews are very important if they're from if it's not just like an intra lab peer review where somebody looks and says, okay, you follow the protocols. Okay. So you have a right after you lose Daubert to raise that. We raised a Daubert issue that we knew we'd lose in Aaron Hernandez, having to do with the people call it ballistics, but it's not. It's the matching. It's the comparative forensic evidence of matching bullets, right? Comparative sciences are always a problem because they rely on an opinion of somebody who just compares, you and I, on that. And we knew we would lose it, but we wanted to raise it for the record. And then the judge said, everything you have in here, Miss Kenny Bodden, including the reports from the government and all, you will be able to use in your cross-examination on that. And that's what we wanted. We wanted to make sure we had that pinned down before we went to trial, because we knew that the judge was not going to. Matter of fact, we didn't even have any hearings. We said, we're just going to rely on what's there. We knew the judge, and he wrote a 1-page opinion that says, but we could use it all in our cross-examination. And we did, obviously. And, everyone says, well, sciences are boring. I had that jury back and forth. They were like a ping pong with me. They understood everything. They were loving it. They were absolutely loving it. And at the end, I had I had 2 pictures. I had pictures of what this expert had said were matching bullets, to the gun that was there. And he had said, well, because they had enough points of comparison that he thought were reliable. And then I was able to point out to him, which the jury could see, all the 100, I'm exaggerating, other places that there was no match. Okay. All right. And the jury was like, okay, we're done. Show and tell, we can see it. Okay. We see exactly and all. So you can make this type of evidence really, really interesting and make the juries really interested in it. That's why I understand when people, like I want to listen to the boring testimony, because it's what I do. Because when I do it, when I'm cross-examining, it ain't going to be boring for you all. Okay. No attorney should have to defend the judge. Right or wrong is right or wrong. The judge is off the wall. Well, I defended her because she is experienced. She's very well thought of. She's changed the rules in Massachusetts to be very user-friendly now for discovery for the defense, which they did not have and all. And she's probably going to the Supreme Judicial Court on an appointment. I'm just going to let you all know that, all right? So you have to give her some respect. But I think she's been wrong. Simple as that. She's been wrong on a lot of things, okay? And I think she's created a lot of problems that she shouldn't have created, all right? So that's what we do. And thank you for saying you love our humor. I know a lot of people have come to say they come and watch this because we can tell things, and yet we can intersperse a little bit of humor in while we're telling it. For instance, when Michel Bryant, as you know, I don't have it. I have a glass case here. I don't think that would do it. Has the tail light, and he says, and he goes up his arm and he goes rah, 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 with a tail light to say, look, the tail light wasn't Chloe. Yeah, is it humorous? But it's also demonstrative. It also shows you that it's ridiculous. Okay. So and yes, our mods work very hard, and sometimes they need a break too. So if we play a little clip that says, are you sure from my cousin Vinny? We're not meaning to demean, we're not meaning to be juvenile, but everyone's trying to get a little bit of a break, get you all to lighten up sometimes. Even I need to lighten up sometimes, as you can see. And you can imagine me in trial. You can imagine me with my trial teams. You can imagine me with my cases, that people that people are like get scared of me. And I say, scared of me? Who can be scared of me? I'm so sweet. Okay. Um, ADHD in the making, Linda, an honest question. Question, will you ever see Bev the same again? You must feel deceived knowing how hard you have worked for your beliefs and career. I will probably see her again at Harvard next year. I actually have never met her, but I probably will see her name at Harvard again next year. And I would say to her, I just thought that she was wrong. I mean, I'd say to her, I just feel, we're teaching people how to do cases, and I think in a case like this, judges really should be just everything they should do should be viewed as fair, whether it's to one side or another. But you know what? We go into cases as defense teams. We always feel the judge is on the prosecution side. Okay, we always get rulings that we believe are wrong. It's the state of the world. The jury goes in believing if you're charged in an indictment, you must be guilty. That's the world we live in. So we always start, if you're talking about a courtroom being and I like to talk about the courtroom being a football field, the 50-yard line, we're supposed to start equally. But in fact, the defense is viewed unequally. They're always viewed way back there, like 20 yards, 30 yards back. And you have to catch up. You have to catch up, and then you have to prevent the prosecution from going forward. And again, one day I'll show you the slide I teach off PowerPoint when I do lectures, from my case in Tennessee, where the Supreme Court reversed on and has had the gateway to innocence as being so important in terms of if you can get a hearing after you're convicted on a habeas. And my client just died. Paul House, was his name, just died. And then we got that reversed, but we went for the retrial. Went for the retrial in Maynardville, Tennessee. Okay, you can look it up. It's not one of those places that easily will fall off of places you want to visit or have visited. Maynardville, Tennessee, very poor area of Tennessee, about outside Knoxville, about 30 miles outside, 25 miles outside Knoxville. And we had Richard Gabriel do the jury questionnaire pro bono for us, because our client, this was all pro bono work we were doing, all of us, with helping the local defender's office with the NAACP actually law area. Is actually one person. And then the Innocence Project was also kicking in to see if I would help, and I said yes, I would do it. And the question was, how do you view defense attorneys? And the answer was, and it had a lot of misspellings in, but the answer basically was, well, they're only doing the job for the person we're going to convict anyway. I say to you, we always feel like we're starting way behind the 50-yard line. We always feel like the judges are against us, and we have to argue. Do you think that Hank Brennan would have to argue this hard to get some of his experts in? No, not at all. They get in. Look, we saw it. They get in without even their dog bite expert we didn't even get to get a Daubert hearing, I should say, on that. They get in. So defense always has to fight, it has to argue, it has to fight, it has to argue. And I always say, as you've heard me say, my view of most judges is they should just get down off the bench and sit with the prosecution team. That's how I feel. All right. So the seems not right, because I think when people become judges, they think, that's they can get de-judged if the police unions go after that, if the prosecutors go after them, right? They don't like judges that dismiss cases. So, we were shocked, most of us, in the New Mexico case dealing with Alec Baldwin, right? Because the judge did the right thing. You had terrible discovery violation. You had special prosecutor, and she was a special prosecutor, by the way, also hiding evidence, logging in under a different case number, so the defense couldn't find it. All right. You can't get any worse than that. Okay. Well, you did get something maybe not almost as bad, if not worse. In Massachusetts, our court clerk, who was very respectful to us, Hernandez, she was clerking for the Superior Court, even though she had been an AG and a lawyer. And the reason why is because of this investigation. Her name was Ann Kaczmarek. She was disbarred, I believe, along with two other attorneys from the state's office, because of their involvement in protecting the lab, the Massachusetts State Police lab, from their scandals, that they had lab technicians that weren't doing their job. Dukan is one. Dookan is one. Either dry labbing, which means that you don't do the test, but you're writing reports and you're stealing the evidence. Dry labbing evidence all over, calling things drugs that they are when they weren't, all sorts of other stuff. And that when people were, and then when they found out the truth, instead of bringing it to the forefront, they were defending it, causing a lot of convictions then to be reversed, a lot of cases to be dismissed, and her license to be taken away. Because you can't go into court then knowing that that's true, and then say to a judge it's not true. But do you know how many judges allowed that stuff in improperly? Okay, all right. Oh, Paula B, no, we're all telling Bev to stop interrupting, not you. Thank you, because I know that when Michael Bryant or I are on, I interrupt him a lot. It's part of our stick, but I have to try to stop interrupting him as much as I do. I'd be the witness that would be like answering the question before the question's finished all the time. You know, and also even when the witness is finishing a question, I'd be like the other day with Jackson. He just, strike that. He's not answering the question. The judge is like allowing the witness to go on and on and on and on and on. Okay. Stevie Sharp, I wouldn't mind if you pause it, so you can feel free to rant without Bev interrupting. You know, we've had this discussion and about pausing, because we know some of the other podcasters do pause and they talk, and then they talk, and then they go back, and then they may quicken it up or not. But unless we're replaying, I kind of like to be in real time. We had this issue at Law and Crime when I was an anchor there, host anchor there for a number of years, and they changed and they went to being like 10 minutes behind in terms of testimony, and they could pause it and they could take out the sidebars. Well, number one, I really hate that, because I think the sidebars are very important to watch why they go up to sidebar, what the question is after they come back from sidebar. And I want to see, sometimes, we're not seeing the sidebars, but people in the courtroom are and can report on what the movement is of the people in the sidebars and all. So I think it's kind of important to see it in real time. Maybe someday we'll think there's a case that we should pause and we should talk in depth about something. But I don't want you moving to a new channel because you want to see what's really happening, and we're behind. We always are going to be a little behind because we have to pull in a stream from somebody else. Now, why is that? Let me give you a sort of a mini rant. The judge has a Zoom, and this case is on Zoom. That's why you hear the goodbye, blah, 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 blah. But you are not allowed to Zoom it unless you have a journalist credential. Even though it's a public Zoom, even though it's paid for by taxpayers, at Justice Serve TV, because we've been denied a press credential because Massachusetts says that being a YouTube channel is not being a journalist, okay? We can't get on there, neither can you. You can't get on the court Zoom, even though it's public, and they'll give you, the office will give you the data of what the Zoom login is. You can watch it, okay? You can get on it, but you can't replay it, and you can't Zoom it. You can't put it into your channel. So all you can do is watch it from the court's public channel, but you can't do anything else. You can't take a photograph of it or all unless you have a press credential. You can't replay it. It's ridiculous. Now, are they doing that maybe because they don't have the capacity to have 1,000 people, 2,000 people taking maybe it'll break down? But then say that we're only allowing journalist credentials on this because we only have the ability to have 100 people on, pulling the channel into Zoom it. Maybe that's what they should say. Oasis Cat has Laura Alessi. Let me just put this up there. This is Laura Alessi. That is Robert Alessi's daughter, and I think Robert Alessi started his Twitter. I just have a feeling maybe his daughter started it for him. She's so proud of dad. Okay. But if you follow her, she will generally follow you back. Okay. Just so you know. A lessinator, what a perfect name. That is funny. To making a candidate. Here's Bev. Let me see here. Oh, I'm sorry, Mara. There you are. A super sticker, Mara. Thank you, Mara, so much. You know, I tried to do an at you last night. I think it was at the show, and for some reason, because I wanted to thank you myself, and for some reason I couldn't. And I must do this wrong. I can't answer you from what I'm on because we have to use a program called StreamYard to pull in the Zoom and to get on. So I have my YouTube here on silent where I can answer you because I can't answer you myself. Missy can, but I can't answer you myself for some reason. But Missy can. And when I tried to do an ad, you wouldn't come up on me. It wouldn't let me come up. So I think I put Mara, and I was trying to thank you. And maybe was it last night? It was one of these days, the last 2 days. So I wanted to thank you very much and let you know that you are seen, and we appreciate all of your donations because these donations actually allow Michael Bryant to do what he does, which is be on the road, which is where he should be in Cannes. I haven't heard from him yet whether he's arrived in Cannes because he was going to do some field work, as I told you first when he arrived, and then probably afterwards. But he's going to definitely be on our 1 o'clock chat, I believe. And we actually gone up there this time with three cords for the Starlink in case those little things break off again. They're so dainty for our mini Starlink. Yes, we had to buy a mini Starlink. But thank you, Mara, because that allows it. We're also waiting, obviously, as you know, to hear from Michael Bryant as decision. The court is expected to rule on the first protester's decision. There was an argument this week in the circuit court about that, about whether the first protesters who were just holding signs, the attorney Randazzo think that went very well, but Michael Bryant's case that he has with Tommy CPU about taking interviews on a public sidewalk as a journalist, whether that should be allowed, whether the order goes too far, that stayed until the judge rules on this case. And the reason why it's apparently stayed is that there's 3 separate judges ruling on the 3 separate cases. So we're hoping that comes out, but it allows Michael Bryant to get up there. And, tomorrow morning, I assume he's going to test that again and try to take an interview. Last time they as you recall, he was there. Trooper Hardin came out and he said, "Look, I'm here recording as a journalist." And then he said, "Well, you don't have you have press credentials on you from everywhere else." I said, "Yeah, because you guys deny me, but I'm actual press. Here's the channel. We now even have gear we can wear just to serve TV um, on it." And then he said, "Well, let me take you inside to the person who runs the courthouse." And apparently that person couldn't be nicer and was going to try to inquire of the office in Boston. Why can't we get the press credential? Because we're media, we are press. So I'm sure Michael Bryant is also going to follow up on him, whether or not he was even answered. And it's kind of ridiculous, especially since yesterday, as you know, in the ruling letting Dr. Turtleboy, Aiden Carney, not go back to jail for alleged violation of an order. Aiden streams on he streams his channel. He has YouTube and he streams, and they call him he's a journalist, right? And the first basically in the second line it says Aiden Carney, a journalist. So Massachusetts' own rules violate what they've done to say that anybody who is a streaming channel, which we are, as you know, we have our bona fides, and Michael Bryant has press credentials for us with Center Street, down in Florida, Atlanta, California, and all. But in Dedham, Massachusetts, in a tiny courtroom that caused the conviction of Sacco Manzetti and their execution, one of which is probably innocent, we can't get that press credential. So we can't stream out of the court's Zoom. That's where I started. Okay. Micah, Linda, do you know how many lawyers can say they were portrayed by one of the best actors of the era? Thank you very much. No, I don't. It was a pleasure. It was a pleasure first to work with Bette Midler until her first day on the set. She hurt her back, and then they had to suspend for a week. And I remember when the producer called me to say that Helen had agreed to portray me, for which she won a SAG award. She as best
Please
actor.
enter the pass.
Oh, well, here you go. We're coming back. All right.
You have joined the
Keep your
meeting as an
questions coming. I
attendee and will be
see Stevie
muted
Sharp.
throughout the meeting.
No, Michael has to have
The host would like you to unmute your microphone. You can.
I'm gonna let you go now, and I'll keep looking at your
All right,
questions.
I
and try to answer them as I
appreciate
can.
the time. I appreciate people's patience. So, in reviewing the rules, I look at Rule 2. So, Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so, upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly where offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So
Okay, I think I let you do it. I think I told you that's what's coming. Actually, excludes the opinion, but because of the fairness, that was unbelievable. But you are free to cross-examine her on her methodology. Probably what he can't say is the court found your methodology unreliable. But, unless he may get there. But that's what I expected her to say. But, I mean, it's disingenuous to say, well, the Massachusetts rules said these rules should be determined to give a just and fair trial, right? And simplicity in administration, and then exclude it because, well, you didn't give me notice. You didn't give me previous notice. All right. Well, you know what? If you find something new, you give the judge notice when you get it, and it doesn't matter. But they got the part, the same thing we did in Hernandez, that you can cross-examine on it all. The only thing I don't know whether she will allow is the specific question: did a court find your methodology in the case in Herrera, Maryland versus Herrera, whatever the site is, unreliable? I bet you that's objected to and excluded when she gets on the stand. But other than that, they got what they needed. And she did the Judge Beverly Canoni thing, rule against the defense. When she first said fairness, I thought, wait a second, maybe she's going to let it in. But then she's got to get the dig, but she didn't give me prior notice. Well, you had to go do your job, Judge. You had to rule from the bench. That's your job, okay? That's why you are there. Okay. All right. Rant is over. Yes. Thank you, Helen Mirren, for winning the SAG award representing me for Screen Actors Guild for Best Actress. Okay. I appreciate that comment, Micah. All right. Let's listen.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan.
The Commonwealth calls Jessica Hyde.
I'm going to actually run behind my avatar. I will be listening for a second. I just have to make a quick pit stop. You all get that.
Follow me, please. Take the clerk and raise your right hand, please.
You solemnly swear the evidence given to the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde.
JESSICA space HYDE.
What do you do for a living?
I'm a digital forensics examiner. I'm also an an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are 3 types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University, a master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. On local time here in Norfolk on January 29th, 2022 from the device that was provided, yes. Not the device, the forensic image, for clarity.
So before we get to the two opinions that you were asked to consider, or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 time frame. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually 3, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran 2 different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual, and on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup, and I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted, or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo, any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 227. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Haas Long to Die in Cold. However, that timestamp isn't about active searches, it's about the time that a tab was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 227. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is Haas Long to Die in the Cold, because that database holds the current search, it constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
Handing you a piece of paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the exhibit that will help you explain?
It will.
I move this to evidence.
Could we approach that? Or have that bit of jacket if you want.
Come on out.
Okay, so we are approaching. We are, by the way, have someone on looking. I have someone out looking for that Maryland case, in case it wasn't cited, and see if we can find it through different sources. Anyhow, through our sources. Here we are with the fan talking again. She's getting to the 227 search, and you know, after she's testified once, she doesn't want to mispronounce a name. I think it's Takamam, sports, and she's an adjunct professor, which means, you teach a course, you get titled adjunct professor. I mean, I'm an adjunct faculty at Harvard too. I mean, for the tall count, tall. It does all is what it is. I'm kind of reading her site and all that type of stuff. But she's like I mean, I am not sure anything that she's done been validated. Yes, can you teach how you generally extract? Can you teach what hashtags mean? Can you teach this? Can you teach that? But I'm thinking her interpretation is really wrong. And also, when I was if I were doing my own research with cross-examination, let's assume Jennifer McCabe opened a different tab and then searched and closed it and then deleted it, but she had the Hockomock Sports tab still open. And then when she went back at 623 and 624, that's the tab she used for the 623 and 624 searches. And therefore, she's saying, well, those searches were really performed at 623 and 624, and there's no really deleted one because she's looking at the wrong tab. She's looking at the wrong area. And believe me, her software is not going to be as good as Axion's software or the other validated ones. And I would have said Celebrate until we learned that Celebrate likes to change the software so it conforms to a police theory of a case. By the way, we are cutting the rant that I did just so you know. And again, I want to thank Mara again before I forget again. Um, you know, but we are cutting my rant on Judge Cannoni's rulings this morning. I really want to read the Maryland case myself because I can't believe she just came in and said that, well, you know, I knew she was going to find a way to exclude it, but I can't believe she came in and read the rule that talked about fairness and justice and fair trial. And they should be construed for that for the defense, and then said, and therefore I'm excluding it. And by the way, you didn't give me enough notice. Well, you know, uh, I'm sorry. Again, I don't want to rant on that again, but I haven't been able to get off that. Okay. All right. So to making account, I'm reading some of your things. I didn't OG original gangster Bosgow. I didn't find her credible in the first trial compared to the defense specialist. I don't find her credible either. Something about the way she testifies and all, and it's kind of weird. It's kind of weird that she's just given this one specific area to do, nothing else. Okay. I am absolutely convinced that that search was a deleted event. I'm absolutely convinced it. All right. And all. So, but the jury, think about this. The jury is hearing, see, Hank Brennan is presenting the prosecution's rebuttal case that would go after the defense, but he's presenting it as his main case. The jury is hearing from this witness that and also the Cellbrite witness. We do have. I will post. We do have something made. I know it's my humor, but Mr. Whiffen, quite the wiffle ball. It was made for us, and I am going to post that because I don't think we can do it here. Maybe we can post that to our members, Missy. What do you think? Can we post that, Mr. Wiffle Ball, to our members? And then it can go out to everybody. So that would be great. All right. It was made for me because I called Ian Whiffen, Mr. Wiffle Ball. I've given names to people lovingly so I can remember them myself in a way. But yeah, Missy, if we could post that to our members, that would be fabulous. A little clip so they could see who made it for me. Joey made it for me, and all. So let's go see. Yeah, Joey Kane made it at Joey Kane. It's wonderful. So we're going to post it to members, and then it can go out to all of you. Maybe before members can see it first, and before our 6 o'clock show tonight, everyone can see it.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected.
This is a ruling that
May I look at my copy of the chart, or no?
She's got it.
Why don't I just ask you?
See if you can answer the questions, and if you can, let us know.
Yes, Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search how long to die in cold?
Correct. I was looking for two searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search of 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Cellbrite Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also use Magnet Axiom.
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image, and that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize, I also used ArtX and Mushy. But ArtX is capital A, lowercase rt, capital E, lowercase x, and then Mushy is M-U-S-H-Y. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrate, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundation's paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month, and to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrate tool to analyze the 227 search, did the search How's Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How's Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How's Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrate.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that that tab was backgrounded, or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How's Long to Die in the Cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out, went and found it, instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, how's long to die in the cold, where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab, and then I make another search in a tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the Artifact Reference Guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how's long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question yet.
Okay. Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those, and I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for browser state DB, cloud tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those, and then I was combining them to timeline out the activity.
At 6:23:51, did you look into how long, TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see is we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 6/24/47, did you identify any artifacts with that search that appears with the timestamp of 2/27/40? Did you find the same?
Correct. At 6/24, we have two timestamps in the same two locations for Ha's long to die in cold, the Knowledge C and the Mobile Safari plist.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "how's long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no?
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how's long to die in cold" was searched at that timestamp tab of 2/27/40?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at sidebar for Mr. Leslie.
Thank you, Your Honor.
Okay, a little technical difficulty with my nails there. Actually, what I was doing was Oasis Cat has posted, has downloaded my rant on the Jessica Hyde matter, and we're going to get one on the medical examiner. She's been so busy this morning. My rant on that, which I promised you. But now we have. Let me just tell you what happened when she first got on the stand. She's allowed to go to question. Then we had an objection to the chart. And that was because Alessi won that objection. Apparently, Brenna was just going to put it up without any background on this chart she wants to use and explain this chart. And I'll guarantee you that Alessi wants to cross-examine her on her conclusions that she puts in the chart. Now there was something that I actually kind of missed. I couldn't hear it. The objection was, she said something about Mr. Alessi wants whatever, and I didn't hear what that was. So they went to sidebar again. Okay, they went to sidebar again. I don't know. We started talking about how all of this is going on in a very strange way because they're trying to discount the 227 search before the defense has had a fully throated objection to it. They've only had McCabe on, and they mentioned it in their opening. But so what the prosecution is doing is trying to, again, influence the jury by blunting what the defense is going to do, okay? And her explanations to me, she just sounds like she just talks a lot. I'm sorry. And I'm looking at her. I'm never using her as a witness. I'm never using her as an expert witness, right? I mean, she just on, because she knows what they want to say. And also, excuse me, I'm having a little technical difficulties because it seems to have blown up your chat here in front of me, and I know that it is blowing up. She wants to just say everybody else, all of their apps, they're bad. Everybody else's apps are bad except for Celebrate now, who's made the change to correct what she's seeing on these things that we've never heard of. And quite frankly, if she's teaching at the FBI, she probably was brought in for some kind of like 1 day seminar where they bring in experts. Who the heck knows? But I'll guarantee you that Alessi has gotten into her background. And if I were them, I would have subpoenaed everything about her on her resume, on her CV, every single thing. I would have subpoenaed about it. And if the court had all in Massachusetts, sometimes the court has to authorize the subpoena. But indeed, I want to show any little thing that she could lie, because she's going, I got this and I told him. Just go look at her page. I mean, this is not the type of expert that I would ever use, but she's there. Now, how did she get there? Did they find her? She's from George Mason. George Mason's obviously a reputable school. She said she's an adjunct professor. I don't even understand why she's already trying to discount the 227 search. And you can get confused if you see it because it could be there. And yeah, all these other people have it on, but there's reasons. There's a danger if you just use the extraction. But if you listen to me, I have analyzed these extractions and I know what I'm talking about. Well, to me, I'm not there with her. Okay. I'm not there with her. I'm simply not there with her. All right. But having said that, all Brendan is trying to do is get the vibe to the jury that what the defense is going to present to you is not real, is not true. That's what he's doing here. All right. He's, it's kind of like the Stockholm syndrome. Oh, come over to my side. Come over to my side. You're with me. Come over to my side. So when the defense goes at you, you're like, well, who are these people trying to fool with me? And he has the judge on his side. Okay. Oh yes, blessed in Texas. Not Osmond. Donnie now Hank made up a word, daubertized. I mean, that's really. I actually thought Alessi had used it too, and he said he wasn't going to use it either, daubertized. So that really kind of is funny for me. By the way, we did post. Micah found Brandy Churchwell had posted the kind of screenshots of the opinion. I don't have the site for it. I don't have the first page yet, but of the opinion of the important part, where the judge said that her methods were unreliable, that her methods, when she examines an extraction report, were unreliable. Now, it's not on a 227 search, sure, all right? But if your whole methodology is unreliable because you're using what you believe, you're the one who really can only tell you what it's like, I'm not buying it. I'm just going to say that again. Ripper Jack Media, thank you for the donation. Ripper Jack Media, wow, what a great name. Linda, please have Michael ask the court there to issue him his freedom of religion pass as well. It's also covered under the First Amendment. All right, I will do that. Does that give us the journalistic privileges to get inside that zone? That's really interesting, but I just screenshotted that, and what I'm going to do is I am going to text that to him right now. I have not heard from him right now, but I know that he will be on, and I know he is busy when he's going. Last time, as you know, he had to go back. This is our 10th trip up there. We're probably one of the podcasts that in a streaming channel that's up there pretty much all of the time, right? Almost. You'll see the big channels there for openings, for closings. If Karen Reed decided to take the stand, which no attorney in the world is going to put her on the stand, they don't need to, where you need to put somebody on the stand is when there's a self-defense case. You don't need to do that here. And when you put somebody on the stand, by the way, everything that you've done before to get to a not guilty verdict goes away, because the only thing that counts is the defendant's testimony. And you know how Hank would make things seem that they're not. It's just the way it is. I mean it all. I really have an issue for all of you, but Ripper Jack, I just texted that to him, so I will ask him to do that. And maybe that would get him into an exemption under the rules for the coverage. But I know he's going to try to test it tomorrow. I know my partner, okay? And remember, because he's the one who was dealt with, I was on the air covering it the day that he was told he couldn't walk on the sidewalk a fifth time. They don't want to see him a fifth time walking on the sidewalk, where he was interviewing people, walking back and forth, and he wasn't stopped. He was just walking back and forth. And he took it upon himself to be a plaintiff in a suit immediately because the First Amendment supporter. So we're not backing down here, guys. All right. But we'll call it as we see it. We'll tell you if we find something that's not good for either side. All right. Let's go back into court. Thank you, Rubberjack
You've
Media.
explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology
Unless
you
he
use
won
that
his
is
objection.
accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How
Sure.
about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
Is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, "How's long to die in cold?"
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "How's long to die in cold" was made at the time of the timestamp 2/27/40?
It's the last time Mr. Leslie on this issue, okay?
Muted. Okay. All right. Let me start again. My mic was muted because I was busy trying to do something to get it on next for you guys. This is outrageous the way Judge Beverly Canoni just said this, and I would make an objection from the jury. This is the last time, Mr. Alessi, on this issue you could approach, okay? I mean, I would make an objection to that because she is telegraphing to the jury that she doesn't like the fact that Alessi is objecting here, and he's perfectly right to object. She's trying to come to a final conclusion and give her final conclusion based on her methodology. He's now objecting to the methodology that she's put out as being accepted in the scientific community. That's what he's doing. And he wants to make that record. He is entitled to object. He is absolutely entitled to object, okay? And for her to say, the judge to say, this is the last time Mr. Alessi on this issue, I think is outrageous. Again, I would object to that. I put that on the record right now. If she wants to hold me in contempt, I'm going to go with Alessi. All right, Alessi, call me, okay? I'll be there for you, along with every other lawyer that's following this that does criminal defense work. That is outrageous, okay? I'm sorry I was muted, but you're getting, I've had 3 rants today. This is the 3rd one, all right? This is the absolute 3rd one, all right? What Alessi has to do in cross-examination, though, is he has to make this simple. She's talking peeless, gobbledygook, da, 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 da. Does anyone really know what she's talking about? Okay, except for the fact she's going to say what the prosecution wants them to say, which is, oh, the 227 search wasn't made at 227, and therefore it wasn't deleted because everybody else was wrong. And by the way, Cellbrite gets, as I tell you, the biggest customer for Cellbrite in the United States is the government. They're the ones who use them. All right. So they changed they even changed their program. Well, I give credit to the ones that didn't change their program to conform with what the truth is. Does anyone not believe that search wasn't made at 227? I believe it was made. I believe it was made, okay, at 227. I absolutely believe it was made because there's 2 different types of searches, and you know, it shows it was deleted. It just didn't get deleted by accident, by some system failure, by some software confusion, as we've heard. It was deleted. So if all this stuff for forensic extraction is valid, right, then it has to be valid. It has to all be valid, okay? It just doesn't get software confusion at the point where the prosecution's case is hurt by it. And that's what's going on here. But Alessi has to make it simple. He's got to bring it into, I like to say, into plain English in front of the jury. Has to make it very, very, very simple, okay? Now, I don't like the way she's testifying. I don't think she's very effective. But again, this is not about whether she is particularly effective, the way Hank is presenting this case. This is about whether Hank is creating the vibe so that when the defense gets up and argues differently, they don't believe the defense because of the vibe that's been created by Hank, which, by the way, just got reinforced by Judge Canoni when she says this is the last time on this issue, Mr. Alessi. They're reinforced. I mean, that has to be an objection. Hello, I'm shouting. Maybe I'm shouting to the defense team at this point. Hello, I'm shouting, okay? Because it is disgusting. It's disgusting. It's embarrassing, all right? I mean, it's truly embarrassing, all right? You know, I mean, you're the one who wanted to do everything at sidebar. You're the one who wanted to make sure that nothing comes in that's helpful for the defense. And quite frankly, as a lawyer, you have to make that record. I don't care what the judge says. I don't care whether she tells him not to stand up again and not make it again. Object again, all right? Object again, all right? Anika wants to know whether the defense can appeal this interlocutory. No, they cannot. Only if she gets convicted can they discuss this. All right, let's go back into court. Let's listen. I'm going to try to go behind my avatar again while I'm posting something
I'm
on
now going to
X
ask
for you,
for
but I'm
your first
listening.
opinion. So you shared that you have an opinion about whether that timestamp 22740 was, whether or not that was the time the search "How long to die in the cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, "How long to die in the cold," occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion, to a degree of scientific certainty, whether there was any other searches similar to "How long to die in the cold" that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm
assume?
sorry, that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
Do you have
thought.
an opinion, to a reasonable degree of scientific certainty, whether there were any other searches on that tab before the final search at 6:24:47, "How long to die in cold"?
Same objection, Your Honor.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Okay. Did you develop a chalk that I
I
showed you
did.
earlier?
Yes.
Like to approach?
Yes.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move, subject to redaction, that this be introduced into evidence.
Your Honor, I have no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. Your rights are safe. Mr.
Thank you, Your
President.
Honor, appreciate it.
Exhibit 82.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. Hyde, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left it says 2:27:40 a.m. and then under the search term it says "How long to die in cold." How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store, how the data is stored, the search term "How long to die in cold" with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. and it provides artifact to cache record.
Mm-hmm.
What is the term, and what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 623:49, we have a cache record that indicates that Apple suggested the phrase, "How long does it take to digest food?"
And then under that, 623:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as "how long, TIDINCIKD," which that is available to us in the mobile Safari plist, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see "how long to die in cold." And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for Browser State DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold was searched at 6:24:18, tracked in that mobile Safari plist, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for Browser State DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 2:27 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
And you offered that the "how long to die in cold" is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that "how long to die in cold" was searched at approximately 6:24 a.m.
Now, moving on from the 2:27 search, there are 2 other issues that you were asked to analyze. And we talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "how long to die in cold," was user deleted on that device.
So there's 2 really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browserstate.db-wall. That's important, so we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that dash wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those wall files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table. But it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be. That wall file can contain deleteds and food or data that hasn't yet been delivered to the database. So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Haslong to Die and Cold. If there was more than one search that had occurred where it became the top element in that database, we would we would see that. There are, as I mentioned, other carved from the database, from the wall file elements such as the search for the YouTube video, It's Raining Men, because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the How's Long to Die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the wall file for that reason. It doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete
close
it.
the tab and then you
can't
clear the
delete
cache.
tab
It's deleted.
history.
Okay?
It's just what tabs
Of course.
are there.
This
The
is ridiculous.
device
This is
is
just
tracking
ridiculous.
that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web or that Safari search is characterized as deleted?
Tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a
You mean
chart
the
in
same
there that
paper
shows
that
the
you
distinction
authored so you
between
could
how
testify in
different tools,
this
some will
case?
use red X's,
Give
some
me
will
a
use
break.
question marks, some will
You know
list
Leslie's gonna
carved
have
or
that.
parsed, so every tool chooses to do that differently. That does
This is
not
her
mean
peer review,
deleted.
her own
It
paper.
means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
An examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the data set generation guidelines, both speak to conducting testing to verify and validate, and it states
This is the kind of
clearly
expert that
an
throws out all the
examiner is
gobbledygook
to
in the world
verify and
because
validate
they know that you
findings
can't
and to
understand all the
determine meaning.
gobbledygook. So Leslie has to
Given
bring
that
it down to
you've
plain
used
English,
multiple
okay?
tools
Has
to look
to.
at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved. And in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting. because of what it appears in the forensics tools.
Hank is
and
trying to get
additional
to the
artifacts
1
that I looked
o'clock
at that are
break,
not
by
parsed
the
by the
way.
forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count 2 and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not on the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing the unified logs, that the system
before the
is
party
deleting the
started
201st
to that
call
starts at
every
8
time a new
o'clock.
call is
8
received
o'clock,
or
okay?
outgoing.
Conveniently.
I have no further questions.
All right, can I see counsel at sidebar regarding scheduling and a few things?
Okay, so this is exactly what I thought. She's gonna. I'll guarantee we're taking a lunch break unless she's gonna start after lunch. Okay. You know, and again, we don't see Jennifer McCabe's. They selectively pick Jennifer McCabe's phones to start at a certain time. We don't see her calls being logged. We see the two. We want to know about the 2:27, 6 o'clock, and 2 o'clock, but not at the 8 o'clock because we don't know how many times she called a John O'Keefe's cell phone. Remember, that's one of the questions we had last night in our show. But I'll tell you what, I'm not impressed with this. I said that we weren't going to do any type of we're going to be good. We're not doing sound effects. But my head, if she's my expert, my head is in my hands because again, I mean, all she does is come in really, all Hank wants her, Brennan wants her to get is that supposedly this 227 search wasn't made at 227. That's all he cares about. He doesn't care about if they understand a word she said, okay? An absolute word she said. And let me tell you, I didn't understand, and excuse me, because it's time to curse, an effing word she said. As my expert, she's not the kind of expert I want. I want somebody who can explain things simply and all. But he gets over the fact that over objection by Leslie, they got to give Leslie credit, stood up and objected and preserved 3 more times after the judge told him it was the last time. He did exactly what a good lawyer should do. And he preserved the right that this was not methodology that's valid. She wrote 1 paper on this that she said is peer reviewed. By whom? 2 people who are her friends? Was this in anticipation of this testimony coming up? Come on, you can't make this up in this case, and that's why people are upset. People are upset. We came in just like, okay, it's an interesting case. Look at the funny thing with the snowblowers, how ridiculous, the snowblowers and the solo cups, put them way over there. They're way over there, the snowblowers and the solo cups, right? I mean, we have gone well past the snowblowers and the solo cups. Now I see in my screen that Michel Bryant hasn't had the, shall we say, he hasn't had the joy of listening. Oops, let's listen. Wait a second. Yes, you have. Let's listen a second.
Thank you. Thank you, Your Honor. Thank you, Your Honor.
Recess for 45 minutes.
45 minutes.
Court,
That means they're going to be
please.
back.
Here's
At
your notebook, follow me.
Yesterday, they were pretty stuck to it. All right. Michel Bryant. Hello.
Hold just hold. I wanted that pizza without sausage. You brought it with sausage. No, I want the waffles. I still want no fries. Where are the fries with it? Do I have to pay for those extra? Is there a longer wait? Okay, I'm sorry. I just said my order had to be clear.
Well, wait a second. Your pizza's always going to be there. It's never going away. It's staying right there. But it really wasn't your pizza, it really wasn't your pizza because you really didn't order it. And when he tells you we're going to order it, you really deleted it. But you're seeing it right there. But it's gone.
I wish I was. I just fixed my audio. Sorry, because it's very windy out here, and I know we were getting laptop audio. I just wish I was 1/10 as smart as this woman, Jessica.
Yeah.
She is a genius, and if you don't believe it, just ask her. So she may.
And by the way, just so you know, in about 3 minutes, I have to leave you for about 3 minutes. Okay.
Okay.
All
3
right.
minutes
So
for 3 minutes. Yes, got it.
3 minutes for 3 minutes.
Okay.
Right.
Yeah. So we got 1 or 2 things we can talk about. Anyway, just my general thoughts of this expert. She's just not. She's just too smart, too not likable. She's not down to earth. She feels like I feel like I'm being lectured to. And then here, let me dumb it down for you. Here's the way this works. You do this, and I just me, but it just doesn't resonate with me. It just annoys me, pisses me off a little bit. But like I said, she may be 100% correct. I have no idea. It ain't getting through to me because of her style, her attitude.
Well, I said that Hank is only calling her for the vibe. He wants to have a vibe that this search doesn't occur at 2:27. That's all he cares about. And what you missed this morning was outrageous. What happened to her with the Leslie? Outrageous. I know you were listening.
I listened on the way up, and I only drove off the road twice as I was listening.
Yeah, and you are in Dedham.
Oh yeah, that's right. Dedham. Look at it. You may notice coming up this weekend. There's some special event. Some mail drive for food or something. Anyway, yes, right, just outside the buffer zone, and that's not a function of my being kicked out because that hasn't happened yet. But just I like to get near the Starlink, so we have the best signal. So the further I wander away from the vehicle, signal gets a little sketchy. So.
All right, yeah. So it was simply outrageous. I posted a rant on it that you can watch. I mean, she comes out and when a ruling, when a Leslie has this case from March out of Maryland, and we've got screenshots of the case, right, where her methodology has been ruled unreliable. Well, it should have been brought to me before. Why should it have been brought to me before?
Yeah,
and then when she cites a rule for fairness in the court. She says up there, and she says,
here's the general analysis on that. The broader any court relies on any law, and this is true of any attorney as well making an argument, the broader rule they rely upon, the less valid their argument, right? Because you can take this broad, super broad argument, yes, fundamental fairness, that's the reason I'm ruling as I am. No, you're ruling that way because you want to, and it's a catch-all, and you don't have anything more specific. That's why you're ruling that way. You had to go wherever you could to find an argument that keeping
Yeah.
out this
And
decision
then
in
you should be
Maryland
brought
is
to me
legit.
further. And then you
What-
should be brought to me further. And then she yells at him. Last time I'm going to see you on this, Mr. Listen.
That's
I mean, I think
totally
her conduct is
inappropriate.
outrageous.
Totally
Right?
inappropriate. You can't call somebody out in front of the jury like that. They don't know what's going on. They don't know what happened. If they were concerned about the defense in anything they've been doing, and they've looked at the court as, quote, neutral, now they're looking at the defense saying, they've definitely pissed off this judge. I wonder why. Now, at a certain point, they may realize that the judge is biased and very much on the side of the prosecution, but it doesn't matter. They shouldn't have to deal with that. They should not have to. These are inappropriate statements. These are the kinds of things that get judges sanctioned, or
Right.
censured.
Right. Right.
And you file a complaint, and somebody should follow up on it because it is so outrageous and so obvious. Any judge knows she can't do that.
Yeah, as a matter of fact, I said there should have been an objection, a sidebar on this, and I think they should ask for a curative instruction. We had this kind of, I was telling that we had this in Hernandez when the judge actually said something to Jose Baez in front of the jury, and he got up there right after the jury left, right there, and said, Your Honor, I want to put this on the record right now, no sidebar. I want to put this, how dare you demean me in front of this jury? If you want to demean me in your chambers in private, but how dare? And the judge came out and gave an instruction and said, I am so sorry. I was rude to Mr. Baez. Please don't take it. I was wrong. He, blah, 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 blah,
Right,
blah.
right. And that's appropriate. And he does two things that way. He makes the record.
You are
and,
being stalked.
And
You are
now.
being stalked. Wait, you are being stalked. You are being
Wait,
stalked.
Who's stalking me now? Oh, there he is. What's happening?
I had a sign bomb you.
How's it going?
Yeah.
Good.
Good. Everything
Hey,
is
Scotty. Yeah, ask Scotty
Scott-
to just stay with you for 3 minutes
It's been
for a
raining
second.
every
while
day.
I
This is
let
the
you-
first night.
Oh, I know. It looked good. The weather looked like it was going to be horrible, but it's turned out obviously pretty usable. What did you want of Scotty? What am I
Scotty, can he stay with you for 3 minutes while I have to take care of a matter?
We'll get it worked in. I got a couple of things I want to talk about. You're not going to be far. I'll flag you down.
Yeah.
Okay.
Okay. All right. I'll be back.
Scotty
I'll be
says
back.
hi. Scotty says hi.
Okay.
Okay.
I'm
Yes.
gonna be
Okay,
right
be
back. Okay.
Okay. You do that. I have some. Are you disappearing? Okay. Because I have a couple of elements. Okay, on an unrelated case, but nonetheless breaking news. In that Harvey Weinstein case that has been underway for the last couple of weeks in New York, in Manhattan, much closer to my home, as a matter of fact. The third, you may remember, this is the retrial, basically, because there were a number of alleged victims of Harvey Weinstein who testified in the first trial, which led to his conviction. So they got that overturned. Now they're having the second trial, which is limiting some of that testimony from those that allege to have been attacked or assaulted by him in the past. That's been limited. But what has been added new is a third complainant. And that third complainant, and it's been listed as a Doe complainant, but I think I can give you, I think if you haven't heard it already, let me see if I can find it for you here. The breaking news is that this person is going to testify this afternoon and will be the real new evidence that is going to be brought forward in this Harvey Weinstein case. So I will tell you, and I'm not doing this out of school. It's legit from sources I've received the information from. Interesting name. I don't know who where she comes from or what the background is yet. We do believe she's in the entertainment industry. Kaja Sokala. Kaja Sokala. Anyway, so she will be testifying this afternoon. Could be a pivotal witness, could be the pivotal witness in the case against Harvey Weinstein. Okay, just want to get that out of the way. A truly breaking news and definitely an impactful witness that's going to take the stand in the Weinstein case coming up this afternoon. Here's another thing. I just posted this. It's for the members at the moment, but I'll flip it to public soon enough. I was over at 34 Fairview this morning, wandering around. I felt that in light of the testimony we've had over the last couple of days from Gallagher and from just yesterday from the officer who was involved with CERT. I got him on my notes here, but his brain is my brain has lost that tidbit of info. He was the guy that was with the CERT team and Tully out at the site at about 5 o'clock the evening after the event, 5 o'clock p.m., right? They waited till dark. Anyway, I thought in light of all that testimony, I wanted to look at two things. Number one, the front boundary of the property at 34 Fairview, right up to that curb. Remember, that's the area they searched, about a 60-foot stretch, not into the street, certainly not on the property, but right along the curb, 3 to 4 feet. So that's what they did. I want to go out there, kind of walk that space just to give you a sense of how it lines up with the rest of the property. So did that. And then across the street, and this comes from Gallagher's testimony, across the street is the home that had the camera, the knot ring camera, right? And there was a big scuffle with Gallagher about what you could see or couldn't see from that camera. And he got real snooty when asked about the location of that house and that camera. And he said, it's not right across the street. It's not. It's diagonal. And it's not. I'll give him that. And you'll see it in this video that I've just posted. But that isn't the biggest issue. It in fact, looks directly across at 32 Fairview, the home next door. My point is, why don't you take a look at the video? Just take a look, you know. I mean, it's a lot of work for you. I get it. You're busy. Got things going on. Deputy Chief Kelleher, who lives in that house, he's busy. Got stuff going on. So what? So there's been a body discovered across the street. Who cares? Who needs to look at the video that might provide some shred of evidence about what happened there? Don't worry about it. So you'll see how that house relates to 34 Fairview and how the search they did, which led to the 6 or 7 pieces of taillight, as well as the shoe, which Officer John O'Keefe was missing, were all found in that very tight little area on the curb side between the flag, just before the flagpole. Okay, so I walked that back and forth a couple of times, and I'm going to go back there this afternoon too, because I want to try and chat with some of the neighbors who I guarantee you are fed up with this. I don't blame them, but I will annoy them one more time just to see if we can get some insight, among other things, on what they saw, heard, didn't see, didn't hear on that night of January 28th, overnight into January 29th, 2022. You know, nobody knows like the folks that are living there and have lived there. So anyway, so check out that video if you're a member. If not, we'll flip the switch on that and make it available to everybody in a little bit, not too long. I gotta get oriented here. So I am just outside the buffer zone. You saw Scott walk up with his sign. He can only have a sign here because he's outside the buffer zone. I did listen to the testimony on the drive up, and I had a question. When they got into this whole Jessica Hyde issue. Whoa! The light's about to fall down on me. Hold on a second. This place, it's always a weather cacophony here. Rain, snow, wind. So my question was, when you had Trooper Keefe on there, not O'Keefe, Trooper Keefe, and they were talking about his testimony, and there were a couple of objections about that, and it was foundational. Had to do with some of the evidence they were trying to bring in under that witness. Then we got into that sidetrack of the Jessica Hyde situation and whether or not that Maryland court decision just relatively recently decided, in which the court found that her work was unreliable, whether that could be brought in as impeachment, as cross-examination. And of course, you guys know as well as I do, of course it should come in. It's perfectly acceptable cross-examination. Now, you might be able to trick her into, and she's so defensive, when Alessi gets a hold of her, there could be blood, because she is so smart and so defensive about anybody that challenges her. You remember it from the first trial. The only thing that's changed so far is her headgear. I don't know if she just had brain surgery. I'm sorry if she did, but she had a headgear of some sort last time too. But once he starts digging into her, and remember, he wasn't here last time. So once he starts digging into her, she's going to be very interesting. Get out your body language materials, and get ready for how this woman reacts to a very serious cross-exam. But what I'm getting at is, if he somehow gets her into a back and forth that talks about her history and other cases that she's worked on and where that reference point comes from, he could get her to open the door wide into that Maryland decision. It's possible. Are you back, LKB? Everything good? You're all right?
I'm back. Everything's fine. Thank you very much, Michael. But thank you for letting me leave you for a few minutes.
Of course. We just gave away $1,000 from you. So I'm sorry you missed
Okay.
that.
All right.
Okay, so I'm talking about the Maryland case in which Judge C has ruled it will not come in as a specific reference when cross-examining Ms. Hyde. It's Hyde, right? Jessica Hyde? Yeah.
Yeah, Jessica. And we posted, we reposted the pieces of it. I don't have the actual site itself, and I put it, just so you know, in our assets for tonight for our show.
Okay. So what I was suggesting was that if Alessi, and if anybody can do it, he can. And remember, she wasn't cross-examined by him last time. he could get her in a corner in which that case is somehow talked about or referenced in a way that the door is open. I'm not saying Judge C isn't going to slam it right in his face again, but that it could be legitimate cross-examination material to impeach something she says on the stand during cross-examination. It's possible. So we'll see. I can't wait to see him do his work.
Micah, I don't believe you really. You see, Micah, I just emailed her to see if she'll email me her research papers.
Yeah.
You're the best. Micah's
Yeah.
the one who's searching around.
Yeah.
At some time, and I have to say, we should have Micah come on. He won a cup, and maybe we should have come on co-host with us one of these days because he's been with us from day one.
Yep, and always has some very interesting insights, which is
Right.
nice. So yeah. So we were also talking about. I had some breaking news in the Weinstein case.
I heard it. I could
Did you hear
hear.
that? Okay.
I heard.
So that'll be a pivotal
on this
witness in that case.
A third witness that wasn't identified previously. I obviously
Yeah.
the defense knew, but so another one of these. Wasn't this the reason the case got reversed because the judge allowed too many witnesses, and now they're allowing another one in that
Well,
wasn't notified?
The biggest difference is she is added to the complaint. She's actually a Jane
Okay.
Doe, no longer Jane Doe, complainant.
Okay.
So
All right.
now she's in. And so obviously she gets to testify and take part in the case. So yeah, interesting. I've been checking with our sources and just to find out how that case is going. And that was a big nugget that I learned about this afternoon.
Wow.
So
Wow. I know.
there's
I know
another
that
case.
We haven't. I know we said we covered, and the problem is we've been covering Karen Reed so much.
I
There's
know.
been so much going on that it's been hard to get back to Harvey Weinstein. And you've got another case going on right down the street.
I know the Diddy case is also underway. They're in jury selection right now. I read something about he actually made a statement in court about to the judge, like, I'm sorry, I'm nervous, or some innocuous statement. But the fact that he said it and he hasn't spoken publicly since he was taken into custody, it became a big thing. But I guess he's and I am definitely going to go down in there. We're going to peek in on that. Maybe we'll do a twofer, do Weinstein and Diddy on the same day, different courtrooms,
Right.
different courthouses, but right down the street. And I hear Diddy's, no hair dye allowed in jail, so he's
gray.
He's gray, pretty much all over. I hear. So,
Yeah,
not all
yeah.
over. I don't know anything about that, but yeah, he's gray.
Yeah. So he's gray. Okay. So what?
Yeah. No, I just think
great.
those are the kinds of things they're like, oh, so that's what I remember when OJ. Same thing happened with OJ. Remember, he was
Yeah.
very gray when he was in prison, and then when he got out, he immediately went back to darker hair. It's a miracle. So,
Yeah.
Okay, so back to this case. I was listening on the way up this morning, and I was concerned and confused, and maybe I just missed it somehow. Trooper Keefe, not O'Keefe,
Right.
but Trooper Keefe was on the stand, and there were a couple of objections along the way about his testimony, and
It's ridiculous.
They never seemed to get resolved, though, and then he was done. So what
Yeah,
happened?
but-
What did I miss?
Okay, so we're gonna post one of my rants on that. Oasis, I think we've kept Oasis and Missy very busy this morning. We did the one rant, obviously, on the whole Jessica Hyde thing, but we're going to try to do another one. I think she's looking for it on what I did. Here's what was ridiculous. Okay, the trooper he's the trooper going to the medical examiner's office, and the cops always send somebody. You can ask my husband, right?
Of course.
They always send somebody to it, and there's been a big deal in forensic science about whether the medical examiner should have any input from police because it could taint their opinion, right? And so and all. And we know in the background, and I retweeted Aidan Carney on this because he's got the text from a Proctor. This is where Proctor's name started revealing his ugly head. Former Trooper Proctor says Giannetti. And he makes it very clear he's former Trooper Proctor, now Mr. Proctor. Okay, makes it very clear he's about that. And so you're doing that because what? You're trying to tell the medical examiner your theory of the case and see if you have your theory of the case as the cops if it goes into it, right? Apparently. There's one where Michael Proctor calls the medical examiner a whack job. We know that, right? Because because she concludes that
Undetermined.
Undetermined, that it's not inconclusive. So she's trying to get in. Did you tell the medical examiner your view of the case or input? No, we gave her no input. Well, did you talk to her and say we only gave her facts? Well, what facts did you?
I
give
know
her?
he was fighting about
Right?
the definition of input versus information and facts. I mean, what a
Right.
dummy.
So
I mean,
because
you
it
look
goes
like
on-
an idiot.
Right. It really goes, it generally usually goes to bias of the final conclusion, which can be, which usually is a homicide or something like that, right? And so that was all going on, and the judge was objecting then Yannetti want to know, did you saw the body? Did the medical examiner see the body? Objection. Okay. Well,
was she looking at the ceiling? Was she? I mean,
you
how
were there at the
absurd!
autopsy. It was absurd. And then then the enemy has to ask, well, did she look at the body? Did you see her look at the body with her eyes? Well, that one kind of got through. Okay.
Yeah.
It's absurd. She's doing the autopsy. He said he's there for the autopsy. Then he says, did you have any, conversation with her after she finished the autopsy about what her findings are, what she found? Objection. What? All right. Did she tell you that this was in the undetermined? Did she make one of the matter of deaths? That's what you're there for, to determine whether or not you're going to investigate. Objection. She wouldn't allow any of that to come in. It's the most ridiculous thing I've ever heard.
I know, and it's just, I think it looks to somebody watching it like somebody's working way too hard to keep out something that we're going to learn anyway. We're going to learn that it's undetermined. Case, and so you got to wonder, well, why are they so annoyed and trying to so hard to keep this out? It must be more important. It must be more important than we think. So now I think it's important that it's undetermined. Right.
And as Mara points out, thank you, Mara. Mara's been one of our supporters. A murder trial for 10 days, and the jury hasn't heard about the autopsy yet. The autopsy, but that the death is undetermined, right?
True.
I mean,
true.
True. But the point is that usually the cops take that, and I was saying the cops take that. And this is where my rant comes in. Oasis, Missy, you've been listening, so we can get it up there. And they want to take it, and if it's a homicide, then they're gonna, they're going to. Go do investigation based on that. Or if they say no, here you missed something here. This was a heart attack, right? They respond to what she says, and so he's trying to get to the response to undetermined. What did they do? What did they try? Instead of So I think we're going to hear that that obviously now the defense has to call everybody, including Proctor, even to get in the test that the medical exam is a whack job.
So here was my question and confusion, because I wasn't in the courtroom. The big issue became, well, when you left, did you have some impression or something, which you would need to further your investigation? And that was all objected to. That was all shut down, right?
Right.
And then the next thing we know, they're having the big battle over Jessica Hyde, and then she ultimately takes the stand.
Resolution.
So is he just excused temporarily, and they're going to bring him back and get into what they didn't get into?
Like,
so they just gave up. The defense
I think
gave up.
And I said the defense. This is where Yannetti. Sometimes you're so right. There's so many objections, and stuff that's admitted all the time. What he could have answered did you have a conversation with her? Yes. As a result of that conversation, when you left the medical's office, did you believe in your mind that the cause of death was undetermined? That was the question, right? He didn't ask that question.
So anyway, the jury.
But it's not his fault. It's not his fault. It really was outrageous.
He should never have been, tripped up as many times as he was for those horrible, unsupported objections. But now the jury knows, okay, this thing about being undetermined is an issue. Now they're maybe more heightened to it than they might have been otherwise. So we'll see.
He was also there for one other thing that I don't know if he started with cutting up the box to show the pieces that were found supposedly.
Oh,
and they had a sidebar because apparently there's a cracked piece now, a little cracked piece. So I got the impression that piece
47 pieces.
I think there's a little crack, and so it's been put in a separate evidence container inside that evidence bag, and it sounds like that it's good for the defense because that piece may have not been taken off. There's another piece that's taken off, a small piece that's off before. So maybe there was one piece in all. So there was that happened, and Keefe did that, but they were really big. The prosecution was really big on. And there's crime scene tape here. There's tape here.
Yes,
right?
how important it is that it's sealed and protected. And I wouldn't be surprised if one of you guys took it home and used it as a footstool for a week. So one thing I thought was interesting about those pieces, not just maybe there's a new piece, but wouldn't you bag them from an evidentiary standpoint in separate bags? Why would you dump all the pieces in one bag?
Yeah, because
are you short of bags?
Right.
Are you running out?
Because if you want to say, what if the prosecution were relying on DNA on the bags, right? You've cross-contaminated them already.
Yeah, it
Yeah,
makes
I
no
have
sense
my,
to me.
yeah,
And there
I
was
have my,
Tully was at the scene, and maybe that explains it. But Tully's at the scene. He's the one who is monitoring the collection. Why did you just grab, how many pieces we have out there? We got 6 or 7. Okay, here's 6 or 7 bags. Put one piece in each bag. Put the shoe in one bag. Doesn't
right.
Stop and Shop have more bags? Come on.
Yeah, I'm saying, so you have all these pieces, right? I've cross-contaminated. I've touched everything in here, right? This is what our little demonstration that we did, the monitoring Jackson with all the stuff going in the bags of the clothes to the hospital. You've touched them all. If it is important, you've cross-contaminated. Doesn't mean it's meaningless. It's totally meaningless.
Yeah,
Oh, by the way, I have my dog walker here while we're on the air. I'm gonna leave you for one moment. I am so sorry.
Okay, that's all right. Let me get
You're
back to some of my
for some
notes.
reason.
Tubi calls, you go. That's just the way it is. So Tubi can go, or whatever else Tubi needs to be doing there. I'm very dog sympathetic, believe me. The dogs rule our lives. You realize that. Once you realize that, then it's cool. Everything's fine. Anyway, so good to be back here in Dedham. I feel like it's been a while, but it's only been really like 4 days. I was here at the end of last week. This week, it looks like, at least we're thinking, it's going to be more routine. Oh my gosh, she's back already.
I'm back around. I am so sorry, everybody. Today has been one of those days. I had something that had to get out in court today. Then I had this phone call I had to attend to, and now I just had to attend to it. I apologize. I
was just talking about how this week penciled out as a quote normal week. It was going to be full days, right? Supposed to be a very productive week. And Judge C said, I believe it was yesterday, maybe it was the day before, that they are either on schedule or a touch ahead of schedule. Well, so much for that, since they shot a hole this morning in the morning session, really, with the whole break to determine whether or not the Jessica Hyde Maryland court decision was coming in or not. That was an hour. I mean, that was just.
And I think that's what she gets angry. She gets angry. That's what she said. You should have brought this to me before. Well, maybe he just found it, or maybe I explained to people what happens is you're in these trials because we can't find a site for this. Okay, you're in these trials. Another lawyer sees that this is coming up, doesn't pay attention, and says, "Oh my God, you got a case with Hyde," or you sent, we have these serve lists, right, on defense attorneys. Yeah, you know what? Such and such has a case with this Jessica Hyde. Let me send you this opinion that may be relevant. They may have just gotten this opinion.
Yeah, and maybe I should make her familiar with my axiom: a trial is a living, breathing thing. It isn't set in stone from day one, and you follow it through to the end. No, twists, turns, planned things, unplanned things, surprises. I mean, you can't be so rigid, unless you have some agenda. That rigidity helps, but you can't be so rigid that it's just like, well, you should have told me about this before. Why? So you don't have to spend 20 minutes, learning the law. Is that just too much trouble for you, Judge? I don't get it.
I don't get it either. She's getting paid. She's sitting up there to do what she's doing, right? This is her job. There's something going on that she wanted to rush this anyhow. You and I know that. There's something behind here because she wanted to be so firm on that April 1st date, right? Something's up.
Yeah, I don't know. I don't know either. Maybe after it's all over and the dust is settled, we'll learn. Maybe some event will take place after the trial is over, but we'll see. In her life, who knows? Maybe she's going to get a sponsorship for a product. I don't know. I hear certain products that she consumes all the time. I don't know anything about it, but I see it pop up all the time. I'm not sure what the basis for that is, but that'd be a good sponsorship. Anyway, so other than the arguments of the morning, where we got to see Leslie get his hackles up, I think officially his hackles were up. Would you agree?
I agree, and I have to tell you, I thought he handled it beautifully because when she then said at that point, he objected to go to the jury. When she then says to him, "That's the last time I'm going to hear you," and I was talking to our viewers and I was saying, "Look, you have to be willing to get those, get the handcuffs on and go to jail. She holds you in contempt." He got back up, got back up, and then she said, "Objection, it's noted. Objection." And he did 3 more times. Okay, good for Alessi.
Yep.
Excuse me.
Yeah, no doubt.
That finger to come out. That finger.
Wait a minute. Which fingers are you showing there?
Actually, I'm just showing you my manicure. I'm just showing that.
All right. Yeah, we used to say in my office when things were getting dicey in a trial, and you can kind of tell, and we would just say, "Take your toothbrush, Take your toothbrush. So in case they exited the courtroom out the back door instead of the front. So.
I actually told that to a client one time. I said, if you don't fire this lawyer, just get your toothbrush ready. I actually said that. And guess what? Fire the lawyer. You know?
There you go. There you go. Yeah. And that's funny because that's the one thing, if you do have to go to jail, and I've not been, the day's not over yet, but I've not been, that toothbrush is going to be a very prized possession. So you can also use it as a shank, apparently, if you shave down the ends. Okay. So what else?
I didn't know that.
What else caught your attention today?
Yeah, let me where my notes go with regard to that. So we talked about we talked about Ms. Hyde and all. I mean, I can't. I mean, I just can't. You know, with regard to somebody pointed out, by the way. Somebody pointed out, by the way, that could be a head covering for somebody who's Hasidic, by the way, Michael. So
yeah, I apologize. Don't know what it is. It's different than the one she wore the first time. That I know. But I'm curious. I'm curious.
Okay, what caught my attention was Hank's use of words. Okay, this really got me. As Alessi's arguing, and you know Alessi, he's very straightforward the way he argues. He has everything. He has all the documents. He's very prepared. The defense is trying to malign this witness. They're trying to dehumanize this witness.
So weird.
And they stand up here using the Constitution to do it.
Well, that's outrageous. Using the Constitution. I remember, side story real quick here. I was in court chambers arguing a matter. It was me against 3 attorneys. And I had a chalk. I had this demonstrative exhibit that I had brought into the chambers. And I talked about what the issues were. And I said, this is a violation of the 14th Amendment. And these attorneys, because of the nature of the case, thought that was so odd that they had to say, you can't bring the Constitution up in this argument. And the judge said, you can't argue the Constitution. So needless to say, I won that argument. But, I think that's what happens. You get so buried in statutes and very specific laws and rules, you kind of forget the big picture. And so, yeah, for the Constitution to be, brought up, probably a good idea. And I don't know where Brennan gets the, dehumanize. I don't even understand what that means. How can you, by challenging somebody's opinion and therefore, the basis of those opinions, how is that dehumanizing somebody?
You know why? Because remember how he tried to cross Dr. Wolf and the judge, I'll allow it. That's how he cross-examines. He cross-examines like the typical mob lawyer cross-examining an informant. Okay, a rat. Okay, that's how he cross-examines, right? Everything.
So he's projecting a little bit. Okay.
Yeah, I think he's projecting a little bit. So I thought that was outrageous. Now, here's what I'm worried about, and you tell me your opinion. This judge allows all the prosecution witnesses to go on and to go on and to go on and on. They don't just answer the question. They have to explain all sorts of other stuff, and then they still don't answer the question. So unless he's going to be objecting a lot, what do you think the judge is going to do here?
To prevent that narrative type response?
Right.
I think, he'll deal with one time. Second time, he'll ask to be heard on it and probably ask for an instruction to the witness. Just answer the question as given. And she has done that rarely, but you really had to lean on her to see that happen. So I think he's going to have to really lean on her to do that. And then if not, if he's getting no help from the court, which would be what I'd expect, he's going to have to tailor his questions in a way that you really can't go any further. And you have the right during that examination to say, excuse me, that's a yes or no question. I'm sure, and we've heard this as well, I'm sure Mr. Brennan or Mr. Lally, whoever gets up to do the redirect on a given witness, I'm sure if they have a follow-up question, they can do that and you can explain. But listen to my question, as Mr. Lewin might say. Listen to my question. And you really have to do that, and you have to lean on them. And it's going to be a tug of war between Alessi and the court, and the witness is going to be caught in between.
Yeah. By the way, Missy's uploading my second rant on Twitter. Is that the medical examiner rant, Missy, that I did this morning on that? My husband is actually in a meeting downstairs today. He's got one of the state of New York meetings. I may try to grab him and see what he thinks and see what he says. Although he doesn't really talk to me about anything that's not my, that's, I mean, what I do, what he did.
You might be able to. Hey, let me tell a quick Dr. Michael Bodden story, and it's not a real story. It colors his impressions on things. this guy's the consummate professional, obviously, right? And so we're talking about a case, and they all deal with murders or something of that sort at some point. And he said homicide. Now, I've always said homicide. And I know you say homicide now, but you're kind of close to Dr. Michael Bodden, homicide.
Right.
I like it just because it sounds like that's what the professional would say. That's what the expert would say. So every time I hear homicide, I think of Dr. Bodden.
Well, you know why? Because he's trained. It's all from the medical with the Latin, and it's homicide. It's not homicide. It's homicide.
As in Homo sapien.
As in
right?
Homo sapien, right? The death of
Yeah.
a person, right? Yeah. So that's why, yeah. So, and when I when I go to these conferences, the medical examiners say homicide. They may adopt, sometimes they'll say homicide just because other people say it, but it's homicide.
Yeah, it's definitely homicide is the colloquialism. There's no doubt about it. But yeah, if you look at the root word Homo sapien, yeah, there you go.
Yeah, off in the Latin. So just like somebody said, who was it said? Oh, Joe Jacqueline the other night when he said we do things at the scene. He said, and we do things in situ. You know what that means at the scene.
In situ,
the Latin,
in situ,
and Latin for at the scene. And by the way, even just off the thing, but I know you all like these little things we throw out. A lot of times, medical examiners will have to do sometimes, depending on the nature of the victim, a real autopsy or examination in the cemetery. Usually happens in a religious case, and they call that an in situ, INSITU,
SITU, yeah, in situ.
Yeah,
and it means, I think the rough translation is at the scene or at the location, something like that. I don't have my Latin dictionary with me, but
Brooklyn says it's not Hasidic. I just pointed out that somebody said it may be. I don't know what it is.
It looked more like she was going to go from the courtroom to a snowboard. It just looked like a shredder cap. I'm just telling you, it looks like a knit cap. That's what it looks like.
Yeah.
So God bless her, whatever it is.
It's the forensic one. She doesn't have the ME one. It's the forensic one. Okay. All right. We're working on it. Michael, I had three rants today.
That may be a record. I'm not sure.
I think it was a record. As a matter of fact, the time went by so fast because I was sitting here as an attorney, so incensed. I was so incensed. I mean, you drove off the road 2 times, so at least you would have 2 of them, right?
Yeah.
Absolutely 2 of them. So, but what I'm getting from this? I'm telling you, when I'm reading from this, Madeira Beach caregiver. Oh, hi, Madeira Beach. I know.
Madeira Beach caregiver. Yes, I can't. It's so bright out
I'll
here.
read it. Yeah. Good afternoon, y'all.
You.
Michael, you're staying overnight in Dedham. Dinner's on me.
Wow. Well, thank you so much.
So great.
And since I'm going to Taco Bell, I'm going to have some leftover money. Thank you. It's great.
Not going to Taco Bell. He's probably going to have one of those juicy hamburgers. Madeira Beach. That is so great.
It has been a while since
FKR establishment, please.
The waterfall burger is pretty good, I must say. I have to say.
I'm going to leave that up. Well, I tell you that though, somebody did tweet X at me last night that the rumor in the courtroom is that the jury likes Hank Brennan and that they like him. All right. And so I said, look, it's always been our opinion that you can't underestimate Hank Brennan.
That's true.
You may not think that you like him. You may not think the world of him, but he knows what he's doing. He's been in the courtroom. He's been around a lot, and he's creating a whole separate, different trial. It's got a different vibe for his client, right? He's avoiding all the issues, and he's doing a rebuttal case in his direct case, so that and the danger here is when they do that. What he wants is, I think he wants a conviction on the. Oh, beep beep to you too. On the second charge, the manslaughter charges, and he's going to say, I think I can convince the jury, just by having all this confusion, that they can go to point A. Look, she's the one who left him off. We have the scene. We have things at the scene. He's dead. She called him. She had, no matter what. And the simple point from A to B is that therefore she must have hit him with the car. That's what I think he's hoping.
Well, yeah, and we've said they're throwing away count number 1 unofficially, and they're focusing on count number 2, and that's to your point. That's exactly what it seems like to me. Although I still think about half their case up to now has been the rebuttal case, and the anticipation of what the defense case is going to be, which is just, in any given case, that's just weird to be this far into a case. What are we, day 11? Today's day 11. And you haven't heard much about the injuries to the victim, except through the defense cross-examination. We heard about black eyes and one swollen eye. We heard about an arm, but that's it. And, so there's so much of the prima facie case that is missing from the prosecution. That's unusual when they spend most of their time refuting what they expect the defense to bring up.
Yeah. And then we also talked this morning because we actually we're at it last night a little bit, and that's the order on, because remember we had Guarino on the stand. Guarino was the one with the text, right, who got all the phone calls, and then we talked a little bit last night on our show, but not during our daytime show, that the judge issued an order because the defense apparently wanted to question Guarino, who missed the 32,000 text in the Sandra Burstmore case, and also missed the deleted 227 text. And I'm still going to say it's deleted because I am not convinced that it's not, that it wasn't made and it wasn't deleted. In fact, I'm convinced the otherwise after this woman testified. They're just trying too hard. But that, and we talked about that order, how that order is wrong. That when you're talking about somebody on the stand who, what else didn't they find? Maybe there's other stuff they didn't find. He didn't find when the prosecution said, could you find all this? So I think it's wrong that they refused to allow that cross-examination too. And she does these, what got me is Brennan waited to after Guarino was like, on the stand to file this, or just around, right? To say, hey, you can't cross-examine. And so the order says allowed because it's allowing no cross-examination.
Right. So it's kind of it's kind of a reverse negative kind of approach. But yeah, it's I have to say, I think it's a closer call than some of these other decisions that she's made. But I still think it's inappropriate that you should be able to go into his practices and procedures. And, have you ever in the past had issues locating texts, extracting them, receiving them from other phones? You realize the nature of the science involved. It's not exact. Have you ever had any problems with that? You're just challenging his methods and what he did in this case. And if he's had problems in other cases, maybe it's relevant to whether he had problems in this case.
You mean like a judge with a forensics data extractor whose opinion wasn't allowed because a court in Maryland of the same status as Judge Beverly Cannoni found that her methodology was unreliable? You mean like that? Like the one on the stand now? Maybe you should be able to be asked about that. It sounds to me that they must have gotten that opinion. I'm sure Leslie has whatever cross-examination, because it must have been a Daubert hearing on that, or some kind of hearing. I bet you he has more than just the opinion, because we can't find it on it may not be a reported opinion.
Yeah, was it a slip opinion, or was it a district court opinion? Was it a federal case?
Superior?
Or state case?
No, a state case, and it's the lowest court, so it may not be a reported opinion.
Well, yeah, if it's was it the trial case or the
yes,
district?
The trial case.
The trial case. Well, normally that's not a reported opinion anyway. That's that may be
Generally,
factually correct, but it would not normally be unless it's appealed and codified as not codified, but then memorialized as a case. You don't really get case law from a trial court level. That's until you appeal it. So that may be why it's not out there, that you can't find it, that it's not.
Yeah, but somebody had the screenshots from it, probably from somebody else. I did text a couple of people asking if they had the actual full opinion. We'll see if we can get it, but you do have if you want to read it, we do have the screenshots. I put them in our assets folder. And then I couldn't find our assets folder tonight. Missy had to help me because, technologically I need Jessica Hyde to help me.
I'll take Kokomo. I'll take Kokomo.
Kokomo.
You can have Jessica. Yeah. So did they, again, I was setting up and kind of missed out on the actual break, lunch break. Did they get done with direct on her?
Yes.
Okay, good.
Cross-examination.
So cross would be very interesting. And
it would be interesting because I'm not sure I first of all, I don't buy this whole thing. She's so confusing, right? And the tabs. She said you can never delete a tab. Well, yeah, everyone got on this stuff. It's deleting tabs all over the place, right?
Yeah, I think to just make that broad statement and think people are going to say, oh, all right. No, I mean, I know that's what got her into her ridiculous menu item on the table, back in the kitchen analogy. I get that. I give her an A for effort, but it didn't help me understand what she's talking about. Most people think if I hit delete, it may be in there somewhere still, but the action of deleting it is going to be recorded. And she's making it sound like, no, that doesn't happen.
That doesn't happen, and then you can actually delete the delete with the cache, but it still may be in there depending on how many times you have to do the cache and it's overwritten. We've all been there. All right, so the reason I'm putting up Joey Kane to be maybe more helpful is Joey Kane created this thing that we're putting into our members only. He created a Mr. Wiffle Ball. You haven't seen it yet.
I did. I actually did see that.
Oh, you did see it? Okay,
yeah,
all right. It was going into our members for because Joey, it was so great. for Ian Whiffen. We're going to call him Mr. Wiffleball. Now we're going to have to merge. You're so creative. We're going to have to merge. Let's see, Fluffer Nutter. That was Nuttall and Flementi. What was his name? Whatever his name was.
Dr.
Mr.
Nuttall, and then the other was the cop, right? That's
Yeah,
the name
no,
you're trying to think
the
of?
other, the EMT guy, Clementi.
Yeah,
I told
Dr.
you,
Nuttall.
whatever.
Okay.
No, the two EMTs. All the EMTs who now have the, I hit him under their belt type situation. And that's, by the way, that's the other thing Hank is hoping, that with all that, they'll just say, okay, she said it, and therefore, blah, 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 blah. She said it, she was drinking, she left him off, she came back, she knew where he was. There's red stuff there, and therefore she's the one who did. That's what Hank is hoping for,
Yeah,
people,
I understand.
Yeah, right. Yeah. So simplicity. But Joey is Joey Kane put it together. Oh, he's a nice on it. Yes, on it. Fluenti and I call them fluffernutters. The two fluffernutters. I don't know how to add the woman in.
Yeah,
Fluffernutter,
good luck with that.
Fluenti.
Good luck blending that together.
I'm sure Flamati. Flamati, that's it. Flamati.
So this is important. How's the buffer zone doing? I think it's doing all right. It's look how quiet it is, because people are kind of wandered off for their own lunch break, and then they'll be wandering back. Certainly the numbers are nothing like they have been. So to be honest, the court has been successful in squashing just the numbers of supporters out here by shunting them to the side.
Right. They said
Yeah, I mean, this is the best place.
TV.
And they actually have a truck out here. I don't know if you can see it. See that black truck where Scotty's flag is flying? They have a TV hooked into that truck. So they're playing. I could hear testimony from that TV while I was getting set up. So they've got their own little viewing station. Just doesn't have the number of bodies there that it has had in the past.
Well, because there's really not many places they can put the lounge chairs. They said that they can't.
No, they can't, because this is
public sidewalk.
This building right here. That's why I'm staying on the sidewalk. This is the post office right next to me. Then you have like a law office, and there's the district court. So they've got a lot of places they can control you.
Yeah, and they control. And I think the other day I said Canton was mowing the lawn. I was actually apparently the post office. The post office decided the other day, when they were talking about the leaf blowers, to mow the wet lawn in the rain.
So that's right here.
And then use leaf blowers. So that's why. That's what they had. They picked that day that they were talking about it, just to bring out the leaf blowers. But I attributed to Canton. It wasn't Canton. It was the United States Post Office.
So, okay, well, whoever's doing their lawn care, they've got bad dandelion problems. So get something on that. Get some pre-emergent bad dandelion.
So Oasis Cat says that Aiden on his show talked about wanting to see people there on Thursday. So maybe tomorrow will be busier. So maybe there's something happening tomorrow, Michael, that you are right in the hot spot about.
Could be,
because you're going to be there tomorrow, right?
So so we can only speculate as to who he thinks is coming on. That's going to be significant. I mean, is it going to be one of the key players? Is it going to be a Higgins, a Matt McCabe, a Brian Albert? Is it going to be one of those folks? Don't know.
Why does he need to call Higgins? I don't think he's going to call Higgins.
He might not.
Matt McCabe. I don't think he needs to call them. If I were him, I'm not calling him. Let the defense call him. You want to get from Higgins that. Yeah, you want to get from Higgins that there was a tall 6'2" man who entered the house, and then the defense going to do. Well, you don't know that wasn't blah blah blah. But the prosecution going to do. They're going to cross-examine them. They're going to put that defense in that position, and that, quite frankly, is a smart move.
Oh, yeah. I mean, obviously, the defense. That's why we've talked about this in terms of the scheduling of the whole trial.
Right.
In most cases, you might have, and these are just rough numbers, 80-20, 70-30, meaning direct case in chief for the prosecution, and then the defense and rebuttal. Kind of, the mass part of the whole procedure is the case in chief for the prosecution, as it should be. They have the burden.
Right.
I'm not going to see that here. I think we're going to see almost an equal length defense case as we see the case in chief.
Now, the danger of that, of course, is that the jury thinks that because the defense presents a case, that they have some burden of proof to prove the facts in the case they presented. But by the way, I've seen the fan, so maybe they will be on time, so to speak.
Hey.
But that's the danger, and I think the defense needs to ask for a charge specifically on that this time.
Yep, I agree, because we know that some of the jurors were unimpressed with the conspiracy theme, effectively shifting the burden to the defense to prove the conspiracy theme, which of course they don't have to do. But that's how they interpreted their case, because it was so detailed and there were so many possibilities. I know that Alan Jackson in the opening tried to foreshadow that, right, by pointing out it. You know who has the burden of proof here. We have all this other crap. Crap was not the legal word he used, but we have all this stuff, and don't look at that shiny object and get distracted. They have the burden of proof.
Yeah. So absolutely. You have other field trip things you want to do this afternoon, right? Because I can cover for you till 4.
Yeah, I'm going to go as soon as we wrap this. I'm just going to head back over to Fairview Avenue. It's about a 15-minute drive, and annoy some neighbors. See if
Okay.
I mean that in the nicest
So what I'll
way.
do is
Put a knock on the door.
I will cover for you till 4 today. Tomorrow, I'm actually going to take a trip up to the cabin with Tubi, the poodle. So I'll try to do that early and be seated by around 11 or 12. But you're there, so
Here's what we're going to try tomorrow, just to give you a sense of the plan. We have some new toys, and so I'm going to be I'm trying to be camped out in front of the courthouse with my new camera setting and a new microphone that we're using specifically for mobility, and I'm going to try and kind of cover the morning on the fly with that gear. From right out in front of the courthouse. So we'll see what happens.
And then I will join you when I can, sometime around lunchtime or there before.
Yep. And then I'll set up in a more
normal
normal location at that point.
Yeah. So so just so the viewers know that the plan is that I'll be covering to 4 today, then Michael will cover for me. We're trying to do a split shift here with everybody because it's we're also doing the evening show, right? Blessed in Texas. Thank you, Blessed. Michael, you're in the perfect spot. Law firm and a post office is the main business of a paralegal, but you're a journalist today. Yes, you are. Yes, you are.
Yeah. Let me know if you need any stamps. Need any stamps? Very good.
And I did send you this to please tell you that apparently Upper Jack Media says it's called a First Amendment pass too, a religious pass, which we should look into. Okay, see, because they can't deny that, can they?
Yeah, I don't know what they would do with that, to be honest with you. But that reminds me, before I do leave,
I am
going to wander over and see Chief Rose, see if he's got any update for me. I don't expect that he will, but I'm going to press him for at least, I don't want you to have to do this. Give me a name so I can pester them. And they may not allow it. They're very into their anonymity when they dump on people in Boston.
Right.
So,
yeah. But he was
pretty
nice.
He was
pretty
great.
Nice to you. Right?
He was great from the day I first met him, which was before the trial by 2 months. Let me wander around the courtroom, get a sense of everything. That's when our press pass was up in the air. We didn't know at that time we were going to be denied 1.5 times. Denied the first time, ignored the second time. So he's been great. Chief Rose, good guy.
Yeah. So a good thing to go check in with him because maybe he's waiting for you to check in with him.
That's very possible. I talked to him last Thursday, so he's had some time.
Yeah. The Beach says, buy him a taco. Buy him a taco with that money.
Buy him a taco. Okay, well,
and then we can arrest you
from Taco Bell. I got it. Okay. I usually get the bean burrito. Now, this is very important Taco Bell information. If you're not on the West Coast, you don't have a choice about the sauce they put on your bean burrito. They put red on there. That's it. There's no choice. I'm telling you, once you go out to the West Coast, I don't know how far from California it strays. I don't know if it's Arizona, Nevada. You get a green bean burrito. It's a green spicy sauce. It is so good. It's a whole different dining experience at Taco Bell. So remember that, the bean burrito with green sauce if you're not in the East. I tried to buy some of that when I was out in California one time. Can I just buy some of that? One of the guys was going to go, yeah, sure. He was going to give me a tub of it for like $20. Then his manager came along and put the kibosh on that. So
well, obviously that $20 was going to go in the pocket. So
of course, I wasn't worried about that. I was getting my merchandise. He can do whatever he wants to do. Anyway, so that's my Taco Bell story.
Blessed in Texas member for 1 month. What is a religious pass purpose? We're going to read the rules and find out. But I would think that it's certainly maybe it's to cover. Well, let's see. I'm not sure. That we're going to find out, right? Maybe it's
what was the specific question? What was that?
What is a religious pass purpose? And that was from our viewer who donated to say that you should get that they do have them. So take a look. Ask the chief.
I will ask him. I'll ask the chief.
Yeah,
there may be a whole different process for that.
Yeah, and all because it's really green verde sauce says Arca is my kryptonite. The green sauce verde sauce. Okay, so that's very Blessed in Texas. Thank you for being a member again, just so you know. Yes.
That's nice,
Blessed in Texas again, Michael. That's verde
Tex Max.
sauce.
Yeah, well, you're in Texas. You've got real Tex-Mex. Taco Bell is a joke. It is what it is. I mean, where else can you feed a family of 5 for $20? But you know, it ain't real Tex-Mex. It's you know, anglicized sort of Mexican food.
I do like the cheese quesadillas, though. I have to say.
I'm not kidding when I say I go
I'm
there.
not
I have a
kidding.
very
Right? Yeah.
specific
No, I
order that I
know.
get.
Yeah. Yeah. No, I
Yeah.
believe you. I believe you. Okay. So now we're into food. But this show wanders, as you can see. You know, as you know, but you know, as we all do, as juries do. You know, I mean, they can't talk about this, right? So what do you think they're talking about? Yes.
Kids, food, trips, where you're from. Yeah.
Yeah. Somebody wanted to know about Alan Jackson. Yeah, Alan, I was the lead attorney in the Phil Spector case. After like the first 2 weeks, I was actually the lead attorney getting it ready. Alan Jackson was the prosecutor. I spent 6 months with Alan Jackson. He and I arguing. All right, you're going to go?
Looks like our friends are back.
I just need a witness.
Okay.
Okay, let's see who the witness is. Hold on a sec. We know it's Hyde. Where is she? Where is she hiding? Ah, get it? Yeah, so she's going to be facing cross-examination. This is not going to be the party that she had planned on, I'll tell you that.
I think it's going to be a different vibe this time with
You think?
Joey Kane just gifted Justice TV 10. Joey.
Thank you, Joey.
Thank you, Joey. Thank you so much, Joey. Good afternoon. Here we go. Let's listen.
Okay,
May I, Your Honor?
Yes.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first one. I apologize. This is the one, I believe it's May. I don't remember the
May
date
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20, yes. That's
Oh,
correct.
Leslie knows his shit.
Then I have the third one. This is the final one regarding the phone that was identified as Miss McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well.
She
I
just said
appreciate
it.
you telling me
She just said
that.
it. State versus Herrera, but if we don't need that, very well. She
In
just said the
March,
opinion.
and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the Friends of the Court, you took a position in that, quote, Friends of the Court brief, correct?
I took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent, I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records, and I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
Who submits the pro se Friends of Court?
You are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution. Right. That's correct.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15?
Page 1529.
The report is.
Would you like the
50
page of the
pages.
report or the page NDA number at the bottom? I can do either way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way
Page
is
7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And that if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
I object.
Can you answer that? Ms. Hyde, can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39.
Okay.
And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last, of an indication of interaction with the device, don't you think it would have been appropriate to look at that 123209 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is...
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report, so I cannot speak to that without going back and reviewing that evidence.
Isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
Boom, kaboom, goodbye. You notice how we get a little off script? The witnesses can't handle it. Pretty important that she doesn't know the
If
lock
you could
was
please
12
turn
minutes after
to,
she said the device was last used.
in the same report, page
And look at her posture, by the way. Watch her posture
1528,
during
which
the
is your page number 6. And I just want you, please, to go to the, just put a placeholder in that, and if you could now just go to the conclusion, which is your page 50. Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis? I
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Can you give me my page number, please?
I will. I'm
Okay,
just,
thank you.
You're welcome. If you could turn to your page 13.
13, Roger.
Remember, she knew her report by heart with the prosecutor. She didn't have to look at anything.
Yes, I'm there.
And do you see an entry that says 12/31/56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Well, hold on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps, and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were citing?
Well, I'll state
In
it
other
again.
words,
I appreciate that.
she took
You're
the
welcome.
limited
So
view
isn't
about
the more
interaction
correct
and say,
way
well, that's not
to state this
interaction because
important
it's the
data
phone
point
calculating a
in your
data
conclusion,
point of steps
instead
that
of
somebody's
saying
making.
active interaction with
She's gone.
with the
Goodbye.
screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32 because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation, I'm reading from your report, correct?
Your interpretation that 12:32 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
She's gone. This is it.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's
If I
agree.
could just finish,
Please,
because if
absolutely,
we
sorry.
talk over each other, the stenographer's not going to get both of us. Thank
Agreed.
you. So it's not my theory, it's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56, they ended 20.398 seconds after that, which just doing the simple math is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page
The jury's looking at her. Remember, she's sitting there. Look, they're looking at her. She's not looking at them anymore. And she's kind of like this way and this
Do you have
way.
my page number for that? I'm sorry.
Yes, and
And
I
she needs her
appreciate
page
that you
numbers
go
for
page
her
numbers, so
report.
I center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome.
Page 6. She doesn't know
Just let
page
me know
6.
when you're
They're all
there.
page
I'm
6.
there.
If you could please go to Apple Health Data Steps.
I'll be quiet now because
And we've been
like, this is
talking about
great.
steps because they're important enough that you put them in a report, correct?
That is correct.
Great.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
That 191.253 seconds equals 3.2 minutes?
Approximately, yes.
Approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is, for your reports, you don't date your reports, so I can't give you a date, but it says...
It's report 3, I believe, is what you're looking at.
Exactly.
Yep.
It's 3. And there is... Bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when
Remember, I said he had to be
there.
simple and bring it to plain English to the jury. This is textbook.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page
Absolutely.
for that time?
And
I do
if it
see
is-
an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no. Is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently, let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
yes.
Mr.
Okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp, and you would find that parlance acceptable?
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023, that is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in May of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right. And you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case, that is
correct.
correct.
And that's been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report.
Call the medical examiner. I feel the homicide. Homicide coming on.
And your findings were pursuant to a request from Detective Lieutenant Brian Tully.
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But
going
it
to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X-Browser State DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words that Google search, "house long to die in cold," was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings.
Mm-hmm.
It starts with, "There were 2 searches of interest that took place on the iOS device," and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's, yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device,
Absolutely,
right?
yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Did you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right, so we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we got
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly. And that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the timestamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next to it,
Correct.
did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have 2 additional times in addition to the 2 times, 2 different numbers added to the 2, correct?
The UTC was a typo. It should say UTC next to those, and the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST, I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So, in terms of your May 2023 report, your first report in this matter,
Yes.
you on page 5, in the sentence underneath the block paragraph state, in the instance of the Google search, House long to die in cold that was recovered from the write-ahead log associated with.
That's correct.
The X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report. Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2/27/40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2/27/40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27/40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony, and if at any point you would like to have a copy of that, if Your Honor would like, I will do it, but I'm going to start and then we'll see how it goes. So, bear with me a moment. Do you recall in that testimony stating that you processed the image in several forensic tools? I used Celebrite Physical Analyzer, and then you list many other tools. Do you remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12.
Thank you.
You're welcome. So, do you recall giving testimony about the various tools you used for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I
Fair
spoke to
enough.
the
I'll
tools
get
I
that for
used.
you. May I approach, Your Honor?
Yes, Mr. Alessi, you offered a transcript. Do you have the whole
I have
transcript?
the whole transcript if that helps.
It might speed things along.
Agreed.
Okay.
We have one out provided from Ms. Hyde. I'm going to give you a transcript.
Thank you, I appreciate it.
112. Is that, let me turn it over to, it's going to be 112. Okay. Yeah. You're welcome.
Thank you so much. And you said we're on 112?
Yes, please.
113, I see it. I see it's highlighted on the copy, so I
Right,
figured
so
that's the
what I
one.
wanted to do, the reason I said 112 is that's where I
Oh,
started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding, so it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did, that's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now if we can go to page 124 of the very same testimony. And feel free to go back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with house long to die in cold.
Can I have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123:13, but if you need to go back further, feel free.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony. On line 16, I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that
Correct.
correctly?
Yes.
And that's associated with the Google search, house long to die in cold, and a 2:27:40 a.m. timestamp, correct?
That is correct.
Now if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read
Correct.
that correctly?
You did.
Not one thing, you said it could be lots of things, correct?
That is correct.
And then you go on in line 10, and you talk more, and then you go down to the bottom. You go down to line 20, and you testified, we cannot tell by this particular artifact what time that
search occurred. Did
Absolutely.
I read that correctly?
Specifically pertaining to that particular artifact that in browser state DB, that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
Mm-hmm.
If you go to page 129 of this transcript,
I'm there.
at the top,
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now if we could turn to page 130 of your testimony.
I need to object.
All right, I'll see you both.
I'm standing by this. You can disagree with me. That's don't mind. I mean, we're just like jurors here talking. I'd say, call the medical examiner, as I said, homicide being committed in the courtroom by Robert Alessi, okay? And as a matter of fact, the judge really now should allow her to be cross-examined on the fact that another court has just recently found her completely unreliable, okay? Completely unreliable, all right? This is a bunch of gobbledygook put together, and Alessi nailed her right at the beginning. And I think that that's what's important. He softened her up, and now he's going into some other things, and then he's going to go back, I'll guarantee you. But he softened her up. Let's go through what some of the notes I wrote. First of all, her contact was with Tully. You notice how she didn't bring all of her emails and everything with her, right? The defense doesn't think they really need them, okay? She had the Herrera opinion with her, by the way, in case they needed it. So I guess what happened is, it sounds to me like what happened, even that maybe the prosecution could have supplied that, right? But I mean, the pages are, yes, okay, I understand about the pages, but initially, because now he's going through it, but when he first started out, let's go through. She's had the phone for like 2 years. She said, well, I didn't work on it for 2 years. We've had the issue for 2 years. It turns out, number one, she didn't know when she was doing one report what the name of the phone that she had was. She relied on the police to tell her. You would think you would do a check to see, by the IME number, the IMI number, all the things we have to give Apple when we call in to get a diagnosis of something wrong with our phone. And it turns out that she's got some things wrong, off by minutes, which really count here, including the steps. She says the last reported interaction with the phone was X. When it turns out the last reported interaction with the phone was right, it turns out that she's got the phone taking steps and moving about, right? After she's got the last interaction, all right? She's got the end of an interaction, and then she's got the phone taking steps, right? She's got the phone taking steps. And then she says, well, then and another report, which is different than her last interaction report, she got the phone not only doing that, she says, well, then that was the end of the health data, but it turns out the health data went on for over 3 minutes. of walking, of walking. So number one, she's got the phone ending last being used at a certain time, which it wasn't in one report. In a second report, she's got the phone reporting that the phone health data ends at a certain time, which it ends three minutes later after an amount of steps are taking. And she doesn't really know, she's so initially I've got everything here. Yeah, I've got my reports, so I don't need that. As soon as it starts getting heated, when she asks for the page number and all that, fine, that's fine, because he is jumping around a little bit on page numbers. But the point is that her reports are different. Then she's using the Sanderson tool, which people do not use, and he's going to get into that. I can tell you that's going to be coming next. And Hank Brennan knows his witness is in trouble. That's why he wanted to go to sidebar with allegedly some kind of objection. He's giving his witness time to let's see whether she takes a mid-afternoon break. We just started, but I guess not. Okay, I'm going to take down my call to the medical examiner.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am
Remember,
going
Brendan
to
apparently hadn't prepped her
go
on
back
this.
just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages, and bear with me. I think this
No
may
problem.
be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly. So
am I correct that here what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
on
proceeding?
that date, that is correct,
Okay,
yes.
so I just wanted to establish that, and you were giving Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that Celebrite and Magnet Axiom, and then you elaborate, both Celebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Celebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I used the specialized Sanderson forensic browser for SQLite, correct? I read
That
that
is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur, that you use the words associated with a Safari Google search, house long to die in the cold?
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Let me just say, her first report says
now
she doesn't know why the search occurred at 2:27, not that it didn't occur.
Leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have,
I have
the
it correct.
chronology correct, Ms. Hyde?
That is correct.
So in December of 2024,
Mm-hmm.
just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 22740 timestamp.
Mm-hmm.
And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a year and a half. Is that approximately from your May 23rd report? Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, Magnet Forensic Axiom showed up, that was removed by Celebrate, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it. correct?
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics,
That is correct.
still shows that timestamp,
Yes,
right?
yes,
But Celebrite doesn't in the automated
that is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct, yes.
However, in December of 2024, when you returned to analyze the 22740 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says.
Mm-hmm.
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term "house long to die in cold," and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's
That's a fair statement. That's a fair statement. Let me rephrase it this way.
Thank you.
You're welcome. In this report, you speak about Celebrite release reports, correct?
Are you referring to the Celebrate release notes that come out?
The release notes at the bottom,
Perfect.
right? You referred to that?
That's correct.
And that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrite's.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down, all the way down to the conclusion. In that report, is there reference to any company other than Celebrite in this entire report?
In this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
No worries, sir. Are you familiar with the phrase Apple
Oh, we're
source
getting
code?
to the Herrera opinion,
Apple's
the back
source code?
door, maybe.
Absolutely, yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct?
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I referred to that as the MB postulate. It's a shorthanded, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't...
My question.
My question is, isn't the best place the best place to go is to the Apple source codes themselves, or are you saying these physical analyzer tools are just as good and the information they pull is just as good as an Apple source code?
Those are very, very, those are incongruent statements. Apple source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation, we don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this.
I probably did because I don't want to answer your question.
The best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't perform, operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science,
methodologies, and that's the Herrera opinion that said she wasn't reliable. I think she's opened the door, and I would go back at it with the judge.
Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever learned of, have you ever spoken with Mr. Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just a question.
I have not had that conversation with Mr. Whiffen, no.
Okay, all right. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
I'm sorry, we have to wait for each other to talk.
Oh, yes, I'm sorry.
It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the History DB of either of those two searches.
So I want to just repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
Boom, boom, and now kaboom.
About PYF PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, a tool one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document, yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained, the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear, I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree?
His statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone? It's yes or no.
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then when I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
You know what he's asking.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is the document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state
Notice
that
how
device
she's finally
is
turning to the jury
and
now.
what make and model
He's
that
setting a
device is
trap,
and
but I
what
know
the
what's going to
current
happen here.
support for that device is.
She doesn't know
There
what's
are
going to happen,
multiple
but I know
types
what's
of
going to happen, and you know what's
extraction
going to happen,
methods
because
of
now she's really confident.
In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
Please.
and I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device, so if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time, ma'am? Yes. Thank you, Your Honor. So, bear with me, it's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right. It was at the bottom of my stack. I had to lift up the other ones to find it. All right. So.
Your Honor, may I assist and point her to a page?
Sure. That'd be
Thank
great.
you. If you could turn to that report on your
She doesn't think
page,
Alessi has this all planned out. She has got
47,
another thought if she thinks she's
and
outsmarting him.
continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or Faraday box. That's correct. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not
if
trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct? Or
No,
incorrect?
you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice would be to Faraday.
That
I
wasn't my
100%
question.
agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report
Sure.
show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yeah.
There is activity on
Absolutely.
this phone,
Absolutely. The
which
phone-
shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box, and that failure is not best practice.
Correct. It is not in accordance
Thank
with the
you.
best practices. I agree. I would have Faradayed it.
Thank you. So
If I,
that's
presuming
that's
all
okay.
things.
I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
Woo, I think we're going to go to a lunch, afternoon break.
Thank you.
Oh, redirect. No, she's not. She's pushing forward. Redirect. She may be the last witness that the prosecution has for today.
Of course.
Whenever you're ready.
Thank you, Mr. Chairman.
You're welcome. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023, May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023, what was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And were you informed why? Was there any context to that?
Probably,
Not
I
to
don't recall
focus
the
on
exact
3 search
conversation that I
terms,
had
to focus on 2
with the
search
DA's
terms.
office and Lieutenant Tully at that time.
That's pretty
but
good.
I'm
Unless you should
assuming
pick that
that I
up.
was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of the district attorney's office?
My analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No.
Would you ever allow anybody to affect your input?
No.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding report number 3, regarding changes to Celebrite software, was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the
Please.
scope? I believe we're talking about report 2. That's the one about the Celebrate change.
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrite software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrite actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrite's own statement?
Please.
Celebrite's statement in...
To yourself.
To myself? Okay, roger that. Thank you. I appreciate that.
That's because that statement is hearsay. Notice how Hank, though, says
Can you repeat the
ability to
question?
Was there
distort.
any reason other than the concern about misinterpreting or distorting?
They said that
So what's your understanding?
my understanding is that it is not a reliable timestamp, and that is why Celebrite removed it.
You were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrite Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrite before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrite give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide. And that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release note. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night, or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from, say, 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag, so usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
She wasn't asked to look to see
You
if
were
data
asked a
was
very
removed.
specific question
She had a very
about
limited
history
scope
DB,
there.
and it was
That's the
simply
thing.
whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context to you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari PLIS, which tracks the history, as well as the Knowledge C DB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the Knowledge C and the Mobile Safari PLIS.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is
but
correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data for January 29, 2022.
That is correct.
Page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps. It could be you're carrying it. It could be that you're in some other kind of motion. You could be on a bicycle. You could any number of things. And the number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
I'm going to deny that question.
Can these health steps occur if somebody's holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical, you could be in a vehicle, you could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you in cross-examination, do you have information or an opinion where Mr. O'Keefe's phone was located around 12/21/10 while those steps registered?
Objection, Your Honor. So,
That's beyond the scope of the process.
It was pointed out to you at 12/21/10 there was a registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that that began at 12/31/56 for 20 seconds.
That's correct. Per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
That appears to be the last before the 6 a.m. hour.
And so that 20 seconds, if it began at 12/31/56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at
That's correct.
12/31/56, what was the last second that evening that Mr. O'Keefe's phone moved?
12/32/16.
And then when you analyzed the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what you mean
Yes.
by the question?
The next movement after 12:32
Is the 6:04.
6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't. That wouldn't be inside my digital evidence, I don't believe.
And the last question is, the next movement at 6:15:14, do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person, it could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Any follow-up, Mr.
yes, please, Your Honor.
Just so we can
May I have a
portal,
moment, Your Honor?
because I think this is going to be the last witness of the day.
I know. Thank you.
Ms. Hyde, you were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the...
Thank you. I appreciate it.
And I'll repeat the question for you.
Thank you.
They heard me say there was a homicide in the courtroom earlier, right? They're coming to take her away. we're trying to, by the way, work on our thumbnail
May I,
for
Your
tonight,
Honor?
so
Thank
we
you.
can have you all portal into tonight's show. But let's listen.
In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other
I'm
published,
sorry, my
but
question
not
is, do they
Celebrite?
state in the release note whether there's a reason for why they concluded?
May I look at the release note, ma'am? Thank you, ma'am. Thank you, Your Honor.
Please try not to talk.
I will,
Sorry, Your Honor.
Thank you.
2.
Not asking you to read it, just asking whether or not they give any reason for the conclusion, not a reliable timestamp.
One moment, I'd like to review what they wrote. Thank
Absolutely.
you.
You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is
unreliable.
move on to Axiom.
Mm-hmm.
You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with the timestamp of carved, correct?
Celebrite uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously, when we did the first case.
Right, but
It's the
currently,
opposite.
Celebrite
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover-
is the timestamp that they show for that artifact. correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone, and that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Sorry.
And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to,
Well, I don't know if that's some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
fair enough, but from 6:04 a.m. until approximately noon on
Correct.
January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay,
My
yeah.
question,
6
and
a.m. to
I'm,
noon, it does not appear to be Faraday.
so to be clear, from 6:04 a.m. on January 29, 2022, until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But yeah, it does not appear to have been placed in Faraday bag.
All right.
No, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but in 100%, it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to hopefully what are the last two categories of questions.
Do you think she gets paid?
With regard to the
Reporters do by the
iPhone
word?
of Jen McCabe.
I didn't see her say sorry, by the way.
Do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto-deletions because I don't know what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs, and what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now, what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said
I know you all
that
wanted to know that you can test the Faraday bag to see if it's gone bad. That's really important.
Issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
What? Is there data that we're concerned? Data could be overwritten. There could have been more stuff on his phone that was overwritten. What are we talking about? Is there data we could be concerned with?
You
oh my gosh!
talked
I
about
think she
in
should say
response to
sorry
Attorney
the
Brennan.
prosecution. Whatever they paid her
The
is too much.
12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
Yeah. To boil it down, isn't it correct that that phone was moving at that time?
May I check the timestamp again?
Absolutely.
I apologize. There's a lot of timestamps going back and forth.
Please do.
12/31/56? Is that
That's the start. Yep.
Oh, yes, this one there definitely is. Yes, yes, yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes.
Thank you. Appreciate again your answering my questions.
Thank you.
I think Hank should cut his losses.
All set.
Thank you, Your Honor.
Boom with that last question. Boom. No matter what you want to say, John's phone was moving to 12/32/16 a.m. Right? 12/32/16 a.m. All right. By the way, I didn't see the story. I'm hoping somebody did clip it and we can use it, Missy, and everyone. I missed it. I'm sorry. As you saw, I was dictating actually on this case to Missy. I think I was. Alessi, you softened her up. You softened her up. Hank knew he took a hit on her. And when you end with that, which, by the way, the defense could have, well, actually, the prosecution couldn't have said anything because Hank went there. That isn't in effect no matter what kind of movement. His phone was moving to 12:32:16 a.m. Boom, kaboom, kaboom, over and over again. Whatever Brennan paid her was simply too much. And quite frankly, what she said is that with regard to the 1227, it's just that Celebrite no longer picks it up.
May I?
But Axiom,
I would like to play clip 15, please.
we're gonna play clips. I'm sorry. He wants to end with clips to try to what's happened.
Hold it, go to Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
I think that's fair. This is, remember, she's giving that out of context. After all, Jen McCabe's come after her.
Sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful afternoon. So we're on schedule, ahead of schedule. We'll reevaluate that tomorrow, and I will see the lawyers at Sidebar as we do as well, about just to talk a little bit about scheduling. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with your social media use. We'll see you tomorrow morning. Thank you.
All right, to the court, please. Close your notebooks to follow me.
Why don't you come on up?
Okay, thank you. I'm muted. Let's put that Edward Scissorhands clip if I can find it back up. Edward Scissorhands has entered Alessi. I don't know how to clip it, and it says right where it is. Missy, Oasis, maybe we can find it. Maybe somebody else clipped it, because if she answers the question, I'd like to know what the question is that Alessi asked and answered, that therefore she looks at Brennan and says, sorry. I mean, that's pretty bad. I mean, she was really terrible for the prosecution. That ending, I mean, if all Alessi had to do was get her to admit the phone was moving at 12:32:16, and then we know after that there had to be a manual hitting of the button, right? A hitting of the, just like my iPhone here. If I'm going to lock it, I'm going to actually manually lock it on the side, right there, manual. There we go, and I'm going to unlock it here. So we know that occurred afterwards too, and we know that Karen Reed hooked in at 12:36 to the Wi-Fi. So that doesn't seem like a long time to drive in the snowstorm back to his house when you're driving very, very, very carefully. As we heard from Whiffen, she was only going like 20 miles an hour, 17 miles an hour, 16 miles an hour. Okay, I actually agree with you, Liz Cole Baker. I love the fact that he ended with that clip. I don't know, maybe you think it's great because you think the state has proven their case. I think it's great because of everything that the jury's now heard about Jen McCabe. It is me or her, right? It is me or her going down. We heard yesterday from the previous clip that when it was discussed that, why did you say, she was discussing the supposedly I hit him. She said, well, that's because McCabe told me that he didn't come in the house, that he hadn't been seen. So then I started thinking about that because McCabe told me, okay? McCabe told me. So this 227 search, the McCabe told me, the fact that John O'Keefe is alive and living and moving about at 12:32:16 a.m., even by the prosecution's expert. I don't think he expected that, because remember how this came about. Alessi caught her in the fact that she reported the 12:31:56 movement, and it appeared that she reported that as the last movement. But in fact, she had not reported that at the last movement, because it was another 3 minutes and 2 seconds or so of movement. I mean, that's when I said, even early on, there's a homicide going on in that courtroom, and the homicide was by somebody has named him the Alessinator. Okay. So I mean, it was unbelievable. And even with the fact of the software at the end, she said something that hadn't been explained. Carved versus scan. Carved is where it gets stored, right? I'm sorry, not expected. I'm sorry. It was card versus Slack, right? Carve versus Slack, and we're in the Axiom software. She said it's exactly where it was expected to be if it had been searched, and then of course deleted. But they found it where it was expected to be found. That's the Axiom software. Then Cellbrite comes in and they change the software and changes where you can find whether you can see things because they say that there could be software confusion, but Axiom actually says it's where it was expected to be found. And that's the company, by the way, that she apparently had worked for as the director before. So that's why, she wasn't going to say anything bad about Axiom. Everything comes with warnings. Your medication that you take comes with anything comes with warnings. But that's why you have people to go through it. It was the first time that the carved space was expected versus carved. I'm sorry. Yeah, it was expected. The 227 search using the Axiom software was exactly where it expected to be made if that had been made. Okay, so when Cellbrite comes back in because they initially don't see it, and then Axiom sees it, and then they say, "Oh yeah, it's there. Let's try to explain to law enforcement why we don't have anything to help their case." They just explain, well, they changed the software, but it still may be there. The thing about it is the software no longer sees it if you just use the software to download, and it goes to show you then that maybe all these Celebrate and all this company is not as great as we thought it was, because maybe things are there that it just doesn't see any longer because they've written software to overwrite what people see. And that's why the interpretation becomes important. And that's why the use of various multiple download software companies software is very important, because some software may see what others can't. It's just if I take off my glasses, right, I won't be able to see what's written there. But if I put on my readers, which I think I took off earlier. Okay, so I'm going to be chalk. I put on my reading glasses. I can see some things, right? If I put on my regular glasses that have both the readers and the long term, I can see the whole picture. So that's why maybe you use 3 or 4 different types of software, because some pick up that others will not. And I really don't like the fact that Cellbrite is writing software to eliminate what you can see, what's expected to be there if you did a search of 227. I think this was, correct me if I'm wrong, but I think that she ended up being a total win for defense here. And that's because who cross-examined her? I don't remember who cross-examined her on the first trial. Do we know? Do we remember? Was it Yannetti? This is because Alessi is a geek. He knew everything. And I quite frankly think that the door should have been open to use the other opinion in Maryland, because she mentioned it was important that the methodology was very important. She's the one who mentioned that. And that a Maryland opinion, the Herrera opinion, which she had with her, and she'd been told that, I guess we don't need this anymore because it's not important. The judge there ruled that her methodology is bad. Her methodology is actually bad. But it turns out the reason why it's bad is, you see, she did so many reports with so many things. And if you put them together, you get the whole picture. But if you take them out and you want to, give the prosecutor what they want, you don't get the whole picture. But with Alessi, you can't get around it. You can't get around it. Parsed was the word. It was parsed versus carved. And the 227 search in Axiom is in the parse file. It's exactly where you'd expected to see it if that search had been made. There's where it was found, exactly where expected to see it. In the carve file, things can be eliminated. You don't see them. And that's when Celebrate eliminated the change of software to take out what you can see. And so it doesn't appear in the parse file anymore. So they're using carved instead. So I think that was really pretty good, although, the pizza analysis was really pretty bad. But how long to die in the cold? She was also given very limited things to look at. She was also given very limited timestamps. And then the thing about that, when we stop we have a car, right? We have a car. My husband and I have a car, an SUV. I actually put my key when we're in the house in a Faraday bag, right? The reason why I do that is because anyone can come past you on a drive, like you're on a little local road, and they can try to get your signal right off your key, right? They can do that. And then duplicate a key or duplicate your signal and steal your car. So my key goes in a Faraday bag. All right, I know that. I close it up. I put it down. She got into the testing of whether your Faraday bag is good or not. One, she's trying to explain the fact that. Oh, let's go in and listen. Hold on. Any hot mic? Anything happening? I don't hear a goodbye yet. I don't hear goodbye yet. I hear people walking around, but then it turns out that John O'Keefe's phone was moving for a long time, and we know that it had a code or something on it, right? So how did they open it? It wasn't in a Faraday bag. How did it get opened? To look at, could things have been wiped off it? Remember who had it? Could they? And you don't get the whole picture because even signals that could be sent could be wiping things off. It just as a matter of course, or things could be changed just as a matter of systems, as we learned out, removing things that may be helpful because the proper police procedures wasn't practiced there, or the best practices wasn't made. And Hank took a hit on that, no matter what you want to say. Quite frankly, if I were Hank Brennan, I would have not even had a redirect on her if she were my witness, because I think that recross by Alessi got to bring things home and more concisely. By the time, of course, the jury had to be like at some point going, "Oh my gosh, these chairs are uncomfortable." These chairs are uncomfortable because she was really talking. All right, so I think that was very helpful to the defense here. And I'm keeping the Edward Scissorhands up there, hoping that we can get that clipped and what question she answered before, because this definitely was a homicide in the courtroom. Between the Herrera opinion, where she was found unreliable, and between this testimony, I would never hire her as an expert witness in a case. But I also think she was done a little dirty by the prosecution because they gave her. Tully is the one who talked to her. Tully is the one who gave her Tully, who that's been involved in this, and you know what I mean. He's bound to become, you get proctored or you get Tullied, I guess. She really, she was, what else is the hashtag and the hash value, and she was saying about the hash values. She even contradicted Whiffen on a number of things, right? And then on the Apple source codes, by the way, and she also talked about that some of these softwares that we thought were so great, that they're automators. They just automate, right? They necessarily don't see everything in the phone. They just automate stuff, and then people have to try to interpret them. But you really can't interpret them really well, despite the fact what she says, because no one really has the Apple source code, right? And then there's a little surprise there because it was a Safari browser, right? We don't know whether or not there was other browsers used by Jen McCabe right now. That was a little throw in there that she threw it. That actually Alessi asked her about the other searches being on the Safari browser. So I'm expecting to see something about that. But the 227 timestamp was definitely in the database, and that the only reason it's not there is Celebrate has told them to do something that deletes it from the and put it into the parts from the put it into the parsed file where you don't see it. Okay, so that's pretty bad, and that to me that's pretty bad. If you're Celebrate and you're getting what you get paid about $200,000
Bag or
a year,
box.
probably.
Do I have that correct?
Correct.
By the
Okay,
state
do
police.
you
Okay. Now, all right. So there, I think that's us trying to find that clip.
use
All
a
right, so
biometric to maybe needing
I'm getting that in my ear
example
about the biometric, right?
of maybe needing to
I'm getting something in my ear about the biometric, and all, but I think we'll probably do that when I get off the air with you. The fan is gone. The judge didn't say anything. I don't know if Michel Bryant is back at the courthouse when they're coming out, because I'm not sure he knows that we're ending here early. But I wrote a number of times, boom, 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 even on here and kaboom, because 12 minutes, she's got 12 minutes of activity at a certain point that's helpful to the defense. Um, just the whole thing. I talk about vibes in courtroom. So what am I going to take away if I'm the jury? Well, I'm going to take away the fact that John O'Keefe was definitely still alive at 12:32:16 a.m. and taking steps. And defense is going to say there's an elevation that also goes with this. They didn't get into that with her. She didn't look at it. That there's an elevation of 3 flights that gets into this. But they're going to say, Missy says, sorry, it's okay, no problem. That there was an elevation to it. But Hank, I don't think I don't know if he actually understood these reports as much as Alessi understood the reports. Clearly, Alessi understood all the reports. And then you notice when she started like talking in like lingo and all. Remember, I told you when you cross-examine an expert, you can't talk in their lingo because you can't keep up with them. When she started getting ahead of him on that, he took it right back and he stopped. He just changed the subject. He said, "But I want to ask you about this." Okay, so it was I thought a brilliant cross-examination. There was some part in the middle that I'm not sure the jury understood, and that's where Jennifer McCabe is on her phone all the time. But then there's a call made. He said, "Did you know about the controversy about the 503 or 506 call to Coco?" And then it turns out that apparently that call may not have been made. And the reason why it's not made because the data concerning it wasn't populating in the phone. I'm not sure the jury quite understood the import of that. But whatever that is, I thought that's at the time that, okay, yes, I understand, but I'm not sure they understand the input of that. But she confirmed the 507. Kimberly Slice said she confirmed the 507 call to Coco, but the data around it didn't populate, right? The data around before and after for 3 hours didn't populate around that phone call. And that's the controversy, I guess, regarding the phone call, because your phone is always populating data, right? Your phone is populating data. It's doing data right now. Michael Bryant is getting exits. So we will not have a guest tonight, but we're probably going to have a future guest that we'll announce later on. But right now he is getting exits right there with him. I don't think there's any feed, Missy, coming from there. I don't think Tom CPU is doing any feed, but he will have the exits and we will show them on the show tonight. He may even show them to the members. I'm not sure what he's planning to do, but he is definitely there getting exits. And you know why? He's listening to me in his earphones. So he's listening to what's happened. But he's got to do this on his iPhone with and all, and to try to get the exits. But you think Leslie could have done a better job? I'm missing on this conversation. Leslie should have asked more questions about the 227 search, says Jeremy Edwards. I thought that he did enough about it. I think that they're going to rely now on their expert, okay? And that's always a decision you have to make when you're crossing. If you get something out of the prosecution's expert, or if you're in a civil case, the other side's expert, then you want to go to your expert to then really hone it out. Because remember, that prosecution's expert is really not your friend, all right? What you're getting out is because you're so good, they weren't expecting she wasn't expecting what hit her, and you saw that. She didn't even look at the jury until the very end when she then started turning again, explaining how Faraday bags work, and then she was like, "Oh yeah, I want to explain this a Faraday bag," and then and it's like who the hell cares about whether you want to test your Faraday bag? All right. But so we did learn also there was no best practices. So I'm going to say to you, I don't think Michael Bryant's coming back on the right now because he's getting their exits right now, even though we usually end at 4. I'm going to end the day with you here a little bit early. Missy, are we ready to portal into our nighttime thumbnail for you all? I know we have almost 400 of you. I have to ask you all, please hit the like button before we go. Yes, hit the like button. It's been a long day for all of us, but it's been a great day. I mean, we're portaling. Okay, so you can portal right over into our 6 o'clock show. Michael Bryant will be on. He's got some interesting footage of things he did today. Plat maps he checked. He talked a little bit about lunch. about the cameras at the chief's house, and because he went back to 34 Fairview Road, and he has been there. He's been talking to people. He went back to talk to some neighbors. Hopefully, we'll have an interesting guest in the future. That's a little bit of a tease. And he will inform us about the exits and see who he has on his cell phone as an exit. But the only way you're going to find out is to come back at 6 o'clock. 6 o'clock. Yes, the sidebar, as we're calling it, from Dedham, Massachusetts. But again, before you go to sleep, please, and before you go to sleep, think about me. Think about that. It tells you where my mind is. Okay, hit that like button, and also, I just want to say something. I saw there was a little bit of friction in the chat. Everybody, let's do this. Okay, let's pretend we're jurors. If anyone has a different opinion, let's talk about it. Because when the jurors get in that jury room, they're going to talk about it. And we've said that we think the greatest danger that where Hank is trying to go is to the easiest road. Let the jury say, what's the easiest road? Convict Karen Reed. We'll tell you when we think of something is bad or good. We think the murder charge is bullshit. But there is a danger on that second charge if the jury doesn't want to see all about this. Okay, so hit that like button, right? Hit the like button, because we also told you, by the way, something you didn't see it before I go. We told you that when Alessi was being rooted at by the judge, and told last time, Mr. Alessi, I said the defense, when they go up there, has to make an objection to that. They have to tell her that she has to issue something curative. And I think I posted it on the, let me see if I can find it right now. That the judge did apologize to the jury right before. She said that she's trying to run things fairly, efficiently, and timely. So if she appears frustrated with the lawyers or cuts them off, she tries not to, but she doesn't think she's doing this. But the lawyers are just doing their job, and she's going to try to keep sidebars at a minimum. So it was sort of an apology. I'd want a little bit more, but it was sort of an apology, because I'm sure they got that, because they went, Judge, we were asking you for, they probably even asked for a mistrial. We were asking you for a mistrial unless you suggested that, because you have embarrassed our lawyers in front of the jury, and we are doing our job. And she did that, and we told you that they had to do that, and guess what? She did it. Okay, so there we go. And that was just before cross-examination. You'll get the scoop here. Why? Because we've tried so many cases, and we've tried high-profile cases, and so I can look at that courtroom and I can tell you where I would object, what I would do, and what the judge needs to do. And the judge needed to tone down, and maybe this was a good lesson for her, because I noticed she wasn't as rude to Alessi today after he got on cross and when he got on recross, and she didn't try to hurry him up. So maybe that's a lesson for us all. Let's try to be kind to each other. Let's try to talk with each other. Let's try to talk our differences out if we have them in the case, because the jury's going to be doing that, okay? And we're going to be doing that again at 6 o'clock tonight with our own Michel Bryant, who's on his 10th trip up there to Dedham and Canton and Staunton and all. And so we have some interesting information for you to reveal, but I can't reveal it. I mean, I can't reveal it, And I want to thank everybody for all of their help today, and all of their help. And we'll see if we can get that clip. We're going to try to clip also my rant dealing with the medical examiner. And I'll see if I can get a special guest maybe to come on. If we can get that clip, Missy. Hint, hint, hint. Okay? All right. See y'all later at 6 o'clock. I'm Linda Kenny Bod. Hit that like button. We're Justice Served TV.